Good morning, everyone. All protocol observed. Welcome to day 2 of the annual Moot court competition. And it is at this time that I am going to invite the Executive Director of SEHAD to make her remarks. And as soon as she's done, court shall go into session. So Ms. Fatia Chiange, you're very welcome to address us.
Thank you so much, Esther. Honorable Justice Mike Chibita, Honorable Lady Justice Eva Luswata, Honorable Justice Geoffrey Wilfred Chiriabwire, Honorable Lady Justice Aida Nachiganda, Honorable Justice Duncan Gaswaga, other stakeholders here with us, civil society, our partners in the Right Here, Right Now program, our partners in the Generation Gender program, and the lecturers, the patrons, the Moot coordinators and students from the 14 universities participating in this Moot, the media, and all other colleagues here with us. Allow me to take this opportunity on behalf of the Center for Health, Human Rights and Development, SEHAD, to warmly welcome you to this 12th Annual National Inter-University Constitutional Law Moot Court Competition. We take pride in this annual Moot event, which is one of our innovations that has been nurtured and sustained since 2014. It is one of those annual events we look forward to each year and host it with a lot of enthusiasm, passion, and commitment because we believe it's a contribution to the nation. SEHAD is a mainstream legal and human rights indigenous non-government organization established in 2010 to pioneer the justiciability of the right to health in Uganda and East Africa with regional and global contribution and impact. We address social injustices, inequalities, and health rights violations in the health systems and other sectors which impact health outcomes for girls, women, and other vulnerable communities. We advance the health rights of vulnerable communities through tested approaches that include litigation, advocacy, research, empowerment, and social movement building to realize equitable health and human rights for all people. The Moot is one of the interventions we use to interest and nurture law students into the art of advocacy, introduce them to court decorum, and practical aspects of litigating the right to health. This annual event inspires and ushers the young generation of lawyers to consider a career in human rights law, which aims to protect the rights of the most vulnerable members of our society. It provides an opportunity for students to interact with judges and for judges to interface with practical aspects of sexual and reproductive health and rights, gender justice, and other aspects of the right to health. The Moot mirrors the importance of a combined approach of litigation and advocacy in the realization of social justice in health. SEHAD's litigation journey started way back in 2011 with the now famous constitutional petition number 16 of 2011. In those years, in the years that followed up to 2014, when we innovated the Moot, SEHAD had litigated several other cases, including cases around child theft in Mulago Hospital, maternal death in Nakaseke, one challenging the Penal Code Act for referring persons with mental disability as idiots and criminal lunatics, among others. Such litigations motivated us to think about exposing students in law schools to such scenarios where they interface with actual court settings to prepare them to argue cases of the right to health before courts. At that time, various universities had started taking on important academic courses such as health, law, and policy as alternative course units. A student was at liberty to choose whether they take such a course or not. We established that students who had taken such courses on health law and policy were undertaking impactful work for society and provided leadership for litigating the earlier cited cases. The Moot enables us to introduce and inculcate a culture of advancing the right to health to students who may not have had an opportunity to take such courses at university, and to build their capacities on actual aspects of litigating health and human rights within Uganda's courts of law. We work with judges and magistrates from various courts within the country to preside over the Moot. We are grateful that the students who have gone through such rigorous processes have never remained the same. The judges and magistrates continue to nurture the students with lived experiences of litigating the right to health, drawing examples from what they see in court. This year's Moot competition has been designed to expose students to litigating legal aspects relating to reproductive health and gender justice within Uganda's courts of law through the use of a hypothetical Moot problem. The competitions draw experiences and expose students to litigating cases before the High Court, the Court of Appeal, and the Supreme Court of Uganda. The Moot specifically focuses on examining the policy, legal and regulatory frameworks, as well as the structural and procedural bottlenecks to accessing reproductive health care. Universities expressed interest, and 14 universities from across the country were selected to take part in the competition. These include Bishop Stuart University, Cavendish University, Gulu University, International University of East Africa. Dates collided with their examination. Our sincere appreciation to the leadership of the universities for providing support to the students through the Moot coordinators to engage in this important process. We offer internship opportunities. We offer internship opportunities for the top students from the Law Moot Court competition to build their capacities further in the field of social justice in health. I want to end by appreciating you, our lordships, for accepting to take these students through the court experience, and we hope that it will be a lifetime change in their lives from this day. I want to again appreciate the finalists, including those who were here yesterday. I thank you for the participation, and I wish you good luck as you embark on the final stage of the Moot process for God and my country. Thank you.
This is the final round of our moots in the Supreme Court of Muwemba, holding at Muwemba. Supreme Court Civil Appeal number 1 of 2025. Aweri Health Lawyers Initiative and Muyodi Juliana versus Attorney General and Light of Grace Medical Center.
Thank you very much. Before they take to the mics, we'll do something a little different. In normal court, she would have read out the names of the judges on the panel, but we didn't give her that information beforehand. So I'm going to ask their lordships to each introduce themselves to you and say something about themselves before we start. We'll start from my extreme left.
Good morning. My name is Aida Nachiganda. I'm a judge of the High Court, currently deployed at the Land Division. Also recently joined the Judiciary, but my previous background was that of a human rights practitioner. I worked with the Uganda Human Rights Commission for 22 years. And by the time I left the Uganda Human Rights Commission, I was the director in charge of complaints, investigations, and legal services. I'm extremely humbled to be here with you today. Thank you.
Good morning to everybody. My name is Geoffrey Chiria Bwire. I am currently a justice of the Court of Appeal and Constitutional Court of Uganda. Previously, I have a fairly wide spectrum of past life. I had an opportunity to serve in the office of the Attorney General of Uganda. I also served in the private sector, in the corporate world, in the financial area, both in a bank and then in an insurance company. I was an in-house counsel. I was a company secretary. And before I went to the bench, I was a general manager. So a slightly unique approach. I have other things which you can go to my website and find out. I have a passion for innovation, and I'm particularly interested in the use of IT and alternative dispute resolution. It's a pleasure also to be here. Thank you.
Thank you, my lord. My name is Eva Luswata Kauma. I'm also a justice at the Court of Appeal, Constitutional Court. And my past life is as a private legal practitioner for over 20 years. So I was one of the few women then who started law firms. And my passion is in human rights, especially issues of women and gender. And I did receive a lot of postgraduate training in human rights. So even as a practicing lawyer, I interested myself in human rights, and I worked with many NGOs like FIDA, and I also participated in starting an NGO that gave legal defense, free legal defense for indigent persons. So these are all areas I like working in, and eventually I met up with Sehud, and I've worked with them as well. I'm also very pleased to be here.
Thank you, my lord. Good morning, everyone. My name is Duncan Gaswaga. I'm a judge of the High Court, attached to the International Crimes Division. I'm also serving as a judge of the African Court on Human and People's Rights. Before that, I worked as an IGG of the Republic of Seychelles. I also worked as an expatriate judge of the Constitutional Court and Supreme Court of the Seychelles. That's a long list. I can stop there, I think. Looking at you this morning just reminds me of a young me, and I know what is going on in your heads, if not your hearts. I do a lot of things with young professionals, especially lawyers, and therefore I'm very, very happy to be here. Thank you so much. Good morning. Mike Chibita, Justice of the Supreme Court of Uganda. Before that, I was Director of Public Prosecutions. Before that, I was a High Court Judge in Masaka and Fort Portal. And before that, I was Executive Assistant to the Commissioner General of URA. And before that, I was in Attorney General's chambers with my brother, Geoffrey here. And both of us, he was a personal assistant to Abu Mayanja Honorable, who was Attorney General. And then he handed over that docket to me. I succeeded him in that office as a personal assistant to the Attorney General. Glad to be here. We are glad to have been invited by Sehud again. You see us putting on different colors at the court. High Court puts on a different color, Court of Appeal a different one, and Supreme Court a different one. We did not have a say in what colors should go where. We just found them there, and we just wear them obediently. If I had a choice, I would rather be wearing the dark one, but here we are. But it gives us pleasure to come here. And we didn't come here because we have a free Friday and we are looking for what we used to call progi. But we come here, as just Gaswaga said, because where you are sitting, we sat there. And we may not have had the opportunity to experience what you are doing, but having reached where we have reached, we feel that it is our duty to give back, to give you exposure and give you training. And so we thank SEHAD for availing this opportunity to you, and also for us to, in a way, small way, give back and help you learn something from us. Please feel free, be confident, don't be rowdy. That is the only thing we ask, because court, we exercise maximum restraint, because when we sit here, we wield a lot of power, including the power to say you will not go home today. You will instead go to a police cell somewhere. And I will just share one example for you about how much, well, let's call it power, but maybe authority. I was hearing a criminal matter in Tororo, and we had told people cell phones, silent, switch off, but we don't want a phone to ring. And immediately I stopped speaking, a phone rang. And somebody dressed like him, we said, can you please handle that situation? So we were in court from 9 up to 5. So at 5, I was adjourning and saying we go. And then somebody whispered to me that, oh, there's a person you order to be taken to the cell. He's there. And if you don't give an order to release him, he will spend the night. I hadn't really given an order for him to go to the cell. But the police officer knew that if a judge has given an order and you have disobeyed it, there is only one place they can keep you for safe custody in the meantime. So their lordships here, their words are not in vain. Once they say something, then you have. So just to say, let's keep law and order, let's listen and give the mooters, the lead mooters, a chance to explain their cases. We thank you very much for honoring us with the invitation to be here, and we look forward to a great experience for all of us. Thank you. So there is a timekeeper, I believe. You'll be the timekeeper, all that you have taken them through. Okay, now I will ask you to call the case again, and then we can go into the business.
In the Supreme Court of Moemba holding at Moemba, Supreme Court Civil Appeal number 1 of 2025, Aweri Masolo Adrian as the first appellant, and Mirembe Linda Namulema as the second appellant, Versing Kamukama Susan as the first respondent, and Ainebiona Marvin as the second respondent. The appellants are Masolo Adrian, the second appellant is Mirembe Linda Namulema. Mirembe Linda Namulema. Then the respondents are Kamukama Susan, Kamukama Susan, and the second respondent is Ainebiona Marvin. Ainebiona Marvin.
Your Lordships, if it may please this Honorable Court, I will reintroduce myself. I'm Kamkama Susan, the Attorney General of the Federal Republic of Moemba, appearing for the respondents, and with me is Counsel Ainebiona Marvin. The appellants are represented by Counsel Masolo Adrian and Counsel Mirembe Linda. Your Lordships, the case before this Honorable Court today is as a result of an appeal made by the appellants resulting from a dissatisfaction of the decision of the Court of Appeal, and the matter is coming to this court for hearing, and we are ready to proceed.
Much obliged. Presiding Judge, Your Lordships, as earlier introduced by my land colleague, the Attorney General of the State of Moemba, my name is Masolo Adrian, appearing with my co-counsel, Mirembe Linda. Your Lordships, this is a second appeal against the judgment of the Appeals Court of Moemba that originated from the judgment of the High Court of Moemba regarding 1, the denial of abortion-related services to Muyodi by Light of Grace Medical Center, the dismissal of Muyodi from Pokot University premised on her pregnancy, the failure of the state to pass laws and policies to ensure access to safe abortions, and lastly, the failure to ensure access to education and health in the state of Moemba. It is on this basis that the appellants present the following grounds of appeal: that the Appeals Court of Moemba erred in law and fact by holding that the failure of Light of Grace Medical Center to provide Muyodi with sexual and reproductive health services violated her right to health. Secondly, that the Appeals Court of Moemba erred in law and fact by holding that the unlawful dismissal of Muyodi from Pokot University based on her pregnancy and its termination did not violate her right to the highest attainable standard of mental health and her freedom from discrimination. Third, that the Appeals Court of Moemba erred in law and fact by holding that the failure of Moemba to put in place laws and policies that protect young women from unsafe abortions, thereby contributing to the high mortality rate of 8 deaths per day, did not violate the right to health and life of its citizens. And lastly, that the Appeals Court of Moemba erred in law and fact by holding that the failure of Moemba to take steps aimed at ensuring access to education and healthcare services for all people, irrespective of their religious beliefs and cultural affiliations, did not violate the right to education and health of its citizens. Your Lordships, the appellants are before this court pursuant to Rule 31 of the Judicial Supreme Court Rules. Much obliged. The appellants are before this court pursuant to Rule 31.
I can see it's 2 of you. So maybe would want to know, you know how much time you have as appellants. Are you going to present yourself? She's not going to say anything? We would love to know.
Much obliged, Your Lordship.
How you intend to distribute your presentations?
I will be addressing this court on the first and second ground of appeal, while my co-counsel will be addressing this court on the third and fourth ground of appeal. The appellants are before this court pursuant to Rule 31 of the Supreme Court Rules of Procedure that grant this court the power to overrule or overturn a decision by the Court of Appeal. Additionally, pursuant to Rule 30, Sub-Rule 1 of the Judicial Supreme Court Rules, this court has the power in instances where the Court of Appeal overturned a decision by the High Court acting in its original jurisdiction to hear a matter on law or fact or mixed law and fact. This was also stated by the Supreme Court in the case of Sereko Joseph versus Bank of Uganda, civil application number 13 of 2009 at page 3. Your Lordships, the case that is before this court is one that indicates the dreams of a young girl that was shattered. Not once, not twice, but thrice. The first time by a schoolmate of hers from Pokot University who raped her. The second time by the failure of the very institution that she hoped would protect her, Pokot University, dismissed her and regarded her as immoral. And the third time by the state that she also hoped would protect her through enacting of policies. It is on this basis that the appellants are before this court to respectfully pray that this court upholds the justice and protects young girls in the state of Muwemba. I will now proceed to address this court on the first ground of appeal regarding the denial of abortion-related services to Muyodi by Light of Grace Medical Center, which the appellants shall submit was 1, a violation of her right to healthcare services and sexual and reproductive health services that entails access to safe abortion. And secondly, that the state, in allowing Light of Grace Medical Center to operate on its strictly no abortion policy that it based on to deny Muyodi a safe abortion, violated its duty to protect the right to health. Regarding our first limb of argument, the right to health care has been made justiciable in the state of Muwemba pursuant to Objective 20 of the National Objectives and Directive Principles of State Policy, read together with Articles 45 and 8A of the Constitution of Muwemba. Additionally, the state of Muwemba has also ratified international treaties that recognize this right, particularly under Article 12 of the International Covenant on Economic, Social and Cultural Rights and Article 14, Clause 2 of the Maputo Protocol. It is the appellant's further submission that the right to access healthcare services includes access to sexual and reproductive health services that entails abortion-related services. And this position has been stated under Article 14, Clause 2 of the Maputo Protocol, and is also echoed under General Comment number 22 on the right to sexual and reproductive health, particularly at paragraph 10. Your Lordships, in the case before this court, paragraph 25 of the Record of Appeal indicates that Muyodi went to Light of Grace Medical Center in a dire state of emergency. She was bleeding and heavily cramping. But Light of Grace Medical Center did not even attend to her, but rather chased her away and dismissed her as a sinner. It is our submission that this was a violation of her right to healthcare services, since they did not bother to attend to her with abortion-related services. I will now proceed to address this court on our second limb of argument, where the appellants submit that the state violated its duty to protect the right to health of its citizens. Article 20 of the Constitution of Muwemba requires all persons to respect, uphold, and promote rights enshrined in the Constitution. Additionally, General Comment number 22 of 2016 on the right to sexual and reproductive health states under paragraph 43 that states have a duty to prevent third parties like Light of Grace Medical Center from putting in place barriers to the enjoyment of sexual and reproductive services. It also goes ahead to state that states, in instances where it allows hospitals to make religious objections to provisions of services, must require that these hospitals that make these objections, 1, refer patients that they cannot work on to other hospitals, but also require that in instances where these patients are in a dire state of emergency, These hospitals should not make these objections and work on the patient to save a life. This has also been stated in the case of Serac versus Nigeria of 2001 at paragraph 57. In the instant case, paragraphs 23 and 22 of the facts indicates that Light of Grace Medical Center did not even bother to refer Muyodi to another hospital that would assist her. It dismissed her and called her a sinner. It is our submission that the state, in allowing institutions to operate like this, violated its duty to protect the right to health.
The clinic turned away the client, calling her a sinner. Why are you attributing this action to the state?
Much obliged, presiding judge. It is our submission that the state has a duty to protect the right to health. And this duty requires the state to ensure that institutions like Light of Grace do not chase away patients in instances where they are in a state of emergency. So it is our submission that this is imputed on the state since it failed to require such institutions to work on patients like Muyodi. Having addressed this court on the first ground of appeal, I will proceed to address this court on the second ground of appeal, where the appellants submit that the Court of Appeal erred in law and fact when it held that Pokot University did not violate the right to be free from discrimination and the right to health of Muyodi when it dismissed her based on her pregnancy. Regarding the right to be free from discrimination, this right has been recognized under Article 21, Clause 2 of the Constitution of Muemba, and is also recognized under Article 2 of the Covenant on Elimination of All Forms of Discrimination against Women. It is the appellant's submission that the differential treatment that was accorded to Muyodi by dismissing her was discriminatory since it was based on unjustifiable grounds and it was disproportionate. The Human Rights Committee has stated in Joan de Vries versus Netherlands of 1984 at paragraph 13 that measures that discriminate against women based on their pregnancy is unjustifiable and therefore discriminatory. In the instant case, paragraph 25 of the facts indicates that Muyodi was dismissed as a result of her pregnancy, whereas the respondents may submit that her dismissal was as a result of her violation of the university's code of conduct. It is our submission that this is not the case, because paragraph 25, particularly at line 2, shows that the person that raped Muyodi, the person that put her in this situation, is still at university. So if the university's goal was to promote discipline, then how comes the person that perpetrated this tragedy is still at university? It is our submission that this was not justifiable and therefore discriminatory. Secondly, regarding proportionality, it is our submission that the dismissal of Muyodi based on her pregnancy was not proportional, since there were
Counsel, are you suggesting that since the male student was not dismissed, would you suggest that what happened to Muyodi should also have happened to the male student? Meaning that if Muyodi was suspended or expelled, then the other one should have also been expelled. Are you suggesting that?
Much obliged, my lord. Yes, that is our submission. Additionally, regarding proportionality, it is the appellant's submission that the dismissal of Muyodi premised on her pregnancy was disproportionate, as there are other less intrusive means that the university could have resorted to promote discipline in Pokot University. The Committee on the Rights of the Child has stated in General Comment number 15 of 2013 on the right of the child to the enjoyment of the highest attainable standard of health at paragraph 56 that institutions can resort to less intrusive means that do not impair the right to education of their students in order to promote discipline. The African Committee of Experts on the Rights of the Child has also stated in the case of Legal and Human Rights Center and Center for Reproductive Health versus Tanzania at paragraph 22 that states can resort to less intrusive means to achieve their objectives. It also stated that these institutions can resort to measures like sex education and peer-to-peer education in order to achieve morality and discipline. It is therefore our submission that in the instant case, the dismissal of Muyodi, premised on her pregnancy, was discriminatory. I will now proceed to address this court on our second limb of argument that the dismissal of Muyodi, premised on her pregnancy, was a violation of her right to health. The appellants reiterate the justiciability of the right to health within the state of Muwemba. We also proceed to submit that pursuant to Article 12 of the International Covenant on Economic, Social and Cultural Rights, read together with General Comment number 22 on the right to sexual and reproductive health, at paragraph 2, states that the right to health includes the right to the highest attainable standard of mental health. It is the appellant's submission that as a result of the dismissal of Muyodi, this subjected her to social stigma that negatively affected her mental health. Vilnius University, in its Journal of Clinical Medicine on Adolescent Pregnancies of 2022 at page 4, has stated that stigma is one of the highest causes of poor mental health among pregnant women. Additionally, the African Committee on the Welfare and Rights of the Child has stated in the case of Legal and Human Rights Center versus Tanzania at paragraph 109 that dismissal of pregnant girls and women based on their pregnancy is a violation of their right to health as they are subjected to stigma. In the instant case, paragraph 25 of the facts indicates that as a result of Muyodi's dismissal, the university professors did not even want to look at her. Her family was greatly disappointed in her, and the people in her village did not want to associate with her. All this is while this is a rape victim, your lordships. It is our submission that this was a violation of her right to the highest attainable standard of mental health. Your lordships, it is on this basis that we pray that this court holds that 1, the High Court did in fact err in law and fact when it held that the denial of abortion-related services...
High Court, are you sure?
Much obliged, my lord. That was a slip of the tongue. The Court of Appeal of Muwemba did in fact err in law and fact when it stated that the denial of Light of Grace Medical Center for abortion-related services for Muyodi was not a violation of her right to health, and 2, that the dismissal of Muyodi by Pokot University was not a violation of her right to be free from discrimination and her right to the highest attainable standard of health. With this, I will now yield the floor to my co-counsel.
Councillor Masolo, you've talked about mental health that your client suffered. All of us here can claim that we are having issues with our mental health. We would want to know, how did it manifest? How did the impact of the treatment that she suffered manifest in as far as affecting her mental health?
Much obliged, my lord. It is our submission that the record of appeal indicates that as a result of her dismissal, Muyodi faced stigma from 1, the people at the university, from her family, and the people in her village. It is our submission that this negatively impacted her mental health. But also, the facts also indicate that Muyodi is from a poor family. It is our submission that her dismissal rendered her future unjustifiable. It made it unexpectable of whether she would be able to return to school, and therefore negatively affected her mental health. Much obliged, my lord. My colleague will address this court in 15 minutes on the third and fourth ground of appeal. Thank you.
Judge presiding, members of the bench, may it please the court. As earlier introduced by my co-counsel, my name is Mirembe Linda Namlema, appearing as co-counsel for the appellant. Your lordships, this case does not only concern Moot Juliana. It represents thousands of women that are left to bleed to death in their houses and in their dormitories, neglected by the institutions that were entrusted with healing, pushed to the side by the institutions that were entrusted with teaching, and above all, abandoned by the very state that promised them dignity, good health, equality, and freedom from discrimination. Allow me demonstrate this while addressing you on the grounds of appeal under ground 3 and ground 4. In regards to ground 3, the appellant submits that the Appeals Court of Muemba erred in law and fact by finding that the failure of Muemba to pass laws that allow women access therapeutic abortion was not a violation of the right to health and life of the women in Muemba. And I will demonstrate this under 2 limbs of argument. That 1, Muemba failed in its obligation to fulfill the right to health by failing to allow women access therapeutic abortion, and then secondly, that Muemba failed in its obligation to respect by criminalizing abortion. Proceeding to the first of these 2. The right to life is a fundamental right. However, it is interlinked with the right to health. We will center our submissions on the right to health as it is the primary avenue through which the right to life is realized. As earlier submitted by my co-counsel, the right to health is justiciable and recognized under the Constitution of the Republic of Muemba under Article 20, Clause 2, read together with Objectives 14 and 20 of the National Objectives and Directive Principles of State Policy. The same right is also recognized under international instruments that Muemba has ratified, including the International Covenant on Economic, Social and Cultural Rights, specifically under Article 12, the Convention on the Elimination of All Forms of Discrimination Against Women under Article 11 and 12, and the Protocol to the African Charter on Human and People's Rights on the rights of women in Africa, specifically under Article 14, Clause 2C. My lords, the right to health imposes an obligation on the state, which is to fulfill, as indicated by the Committee on Economic, Social and Cultural Rights in its general comment number 14, in its general comment number 22 at paragraph 45, that the state has a duty to pass laws that allow women access therapeutic abortion. The right to health, as indicated by this same committee, in its general comment number 14, on paragraph 14, includes the right to sexual and reproductive health, which also encompasses medical abortion. The Supreme Court of Nepal held in Lakshmi versus the government of Nepal that the state of Nepal had a duty to pass a comprehensive legal framework that allows women access therapeutic abortion. In the instant case, your lordships, Muemba has not passed a comprehensive legal framework that allows women access therapeutic abortion, which has forced women like Moot Juliana to turn to unsafe abortions, which has increased the maternal mortality rate in the state of Muemba. The respondent may argue that the state has enacted laws that allow women access therapeutic abortion under the Constitution of the Republic of Muemba under Article 22, Clause 2, and Section 152 of the Penal Code of the state of Muemba. However, the appellant submits that what exists under Article 22, Clause 2 and Section 152 of the Penal Code is not a comprehensive legal framework, but rather a limitative application, as it does not recognize other instances that are permitted under international law, including instances of rape, defilement, fetal anomalies, and in cases of incest. Therefore, my lords, the respondent may argue that the right to health is subject to progressive realization. However, the appellant submits that, despite the fact that the right to health is subject to progressive realization, the state still has a duty to meet the minimum core obligations, which is to pass laws. Therefore, my lords, since the respondent failed to pass laws that allow women access safe abortions, and yet 8 women and young girls are dying every single day that passes by, we pray that this honorable court declares that the Court of Appeal erred in law and fact by finding that their failure did not amount to a violation of the right to health and subsequently the right to life. Which brings me to my second argument, that Moemba has failed in its obligation to respect the right to health by criminalizing abortion. The World Health Organization, in its 2022 abortion care guidelines, specifically under guideline 2.2.1, noted that the criminalization of abortion does not stop abortion, but rather makes the abortions unsafe. My lords, it was indicated by the CEDAW committee in its General Comment 24, on paragraph 31, that states have a duty to revisit criminalizing laws that prevent women from accessing therapeutic abortions. This was the same position of the Human Rights Committee in their General Comment number 36, which permits states to regulate access to willful abortion, but in exercise of their powers, they should not limit women's access to therapeutic abortion. Therefore, my lords, in the instant case, the respondent state criminalized abortion under Article 22 of the Constitution and Section 152 of the Penal Code, which created barriers for women in Moemba as they could not access safe abortions, which forced them, like women like Muyodi, to now turn to unsafe abortions, which almost left her lifeless. We therefore pray to this honorable court that it upholds the decision in the High Court that the actions of the respondent violated the right to health and life of the women in Moemba. After addressing you, my lords, on issues on grounds 3 of appeal, allow me proceed to address you on ground 4 of the appeal. In regards to ground 4, the appellant submits that the Court of Appeal of Moemba erred in law by finding that the failure of Moemba to ensure equal access to health and education services for all its citizens, irrespective of culture and religious affiliations, was not a violation of the right to education and health of the Constitution of Moemba. My lords, in addressing this, allow me address you under 2 limbs of argument. That Moemba has failed to ensure equal access to healthcare services for all its citizens, and then secondly, Moemba has failed to ensure equal access to education, and in specifically the right to sexuality education. Proceeding to the first of these two, as earlier stated, the Committee on Economic, Social and Cultural Rights in its General Comment number 14, under paragraph 14, recognizes that the right to health includes the right to safe abortion, includes the right to sexual and reproductive health, which encompasses the right to access therapeutic abortion. The state of Moemba, in the state of Moemba, abortion services and post-abortion services are denied on basis of conscientious objections, whereby private institutions declare that they won't offer such services as they contravene their religious doctrines. The state of Moemba, under the record, under paragraph 8, indicate that Moemba is a secular state. However, it has permitted private institutions, especially those in health sectors, to conscientiously object to providing sexual and reproductive health services, and in particular abortion, based on their religious doctrines. However, it has not gone ahead to put a framework or regulations or guidelines that are guiding these particular institutions under what instances these institutions could cite contentious abortion, conscientious objections, and what obligations arise out of conscientious objections. It was indicated in the New Zealand Supreme Court in New Zealand Health Professionals Alliance versus Attorney General that the obligation to refer is a quid pro quo to conscientiously object at all. Therefore, in the event that these private institutions object basing on their religious doctrines, they then have an obligation to refer these particular patients to other alternative facilities that would be able to provide them with these services, which the state of Moemba has not done. It has not put in place a framework that compels these institutions to go ahead and refer refer these patients to other alternative hospitals that would be able to provide these services. Therefore, we submit that the state of Muwemba failed in its obligation to ensure equal access to health care. Which brings me to my second head argument, that to refer the patient to an alternative health facility.
Is that a recognized obligation in the international legal framework? Is that a recognized obligation?
Much obliged, my lord. Yes, it is a recognized obligation, as was stated by the African Commission in its general comment number 2 on paragraph 26, that contentious objections are not prohibited. However, institutions are prohibited from citing contentious objections in cases where the mother's life is at serious risk, and secondly, the resulting obligation is to refer that particular woman to another facility that would be able to provide such services. Now, proceeding to the second limb of argument, that the state of Muwemba has failed to ensure equal access to education for all its citizens, and in particular, sexuality education. The right to education is recognized under the Constitution of the Republic of Muwemba under Article 20, Clause 2, read together with Article 30 and read together with Article 34, Clause 2 of the Constitution. This same right is also recognized under international instruments that Muwemba has ratified, including the African Charter on Human and People's Rights under Article 17, and the International Covenant on Economic, Social and Cultural Rights under Article 13. It was indicated or stated by Lady Justice Lydia Mugambe in Sehad versus Attorney General and Family Life Network that the right to health, that the right to education includes the right to sexuality education, and therefore states have a duty to develop and enforce a comprehensive sexuality framework. This was re-echoed by the Committee on Economic, Social and Cultural Rights, where it noted in its general comment number 22, specifically paragraph 47 and 63, whereby it indicated that states have a duty to teach comprehensive sexuality education and to ensure that it is incorporated into the national curriculum. In the instant case, my lords, despite the fact that the appellant recognizes that the state of Muwemba issued the national framework for sexuality education, however, it has only been incorporated into schools in 9 out of 22 education regions, which has limited access for other citizens in Muwemba to sexuality education.
Before you proceed, you just quoted the judgment by Justice Mugambe. Yes, can you address court on the status of that case vis-a-vis this court? Is it binding on us? Is it persuasive? How should we consider it? What is its weight?
Much obliged, my lord. In response to your question, the case of Sehad versus Attorney General and Family Life Network was a case in the High Court of the Republic of Uganda, which dealt with access to sexuality education, which imposed on states an obligation to teach sexuality education to its citizens. It is persuasive in nature to this honorable court, and we therefore pray that this court considers this case, and we pray that this honorable court considers and be persuaded by this case. Much obliged, my lord. The state of Muwemba, as earlier stated, is a secular state. However, it permitted these institutions, especially the religious institutions, to set policies that align with their religious doctrines, which in turn limited access to services like sexuality education, because in that 11 education regions, sexuality education was objected to on the grounds that it was contentious, and secondly, these faith-led education boards considered it contradictory to their religious doctrines. We recognize the social and cultural context of the state of Muwemba. However, this does not discharge the obligation of the state of Muwemba, as it has to take further steps to ensure full incorporation of sexuality education in all the curriculums of the schools in Muwemba, by one sensitizing and educating these faith-led education boards about the dangers of not teaching sexuality education, as it is evident from the facts under paragraph 13, that areas where there is no sexuality education is where we have the highest number of adolescent pregnancies, unsafe abortions, and likewise the high maternal mortality rates. We therefore pray to this Honorable Court to find that Muwemba's failure to ensure equal access to sexuality education for all its citizens was a violation of the right to education of these particular citizens. Therefore, my lords, in light of the above submissions, we pray to this Honorable Court that it reverses the decisions of the Court of Appeal and uphold the decision of the High Court in determining and finding that the failure of the state of Muwemba to enact laws that allow women access safe abortions was a violation of the right to life and health of the people in Muwemba, and also that the failure of the state to ensure equal access to education and healthcare services for all its citizens, irrespective of cultural affiliations, was a violation of the right to education and health for its citizens, and also to declare that the Court of Appeal erred in law by finding that the unlawful dismissal of Muyodi was not a violation of her right to the highest attainable standard of mental and physical health, and also to find that the Appeals Court of Muwemba erred in law and fact by holding that the failure of Light of Grace Center to provide Muyodi with sexual and reproductive health care was a violation of her right to health. Therefore, in regards to these submissions, we pray that this Honorable Court declares that upholds the decision of the High Court and the costs be borne by both parties. If I'm of no further indulgence to this Honorable Court, the appellant submits.
Okay, so let me.
Thank you, Mr. Masolo and Ms. Mirembe. I have a couple of questions which I hope you can help clarify my mind on. I wonder if you have addressed your mind to Article 126 of the Constitution of Muwemba, which provides that judicial power is derived from the people and must be exercised in the name of the people, in conformity with the law, in conformity with the norms, in conformity with the aspiration of those people. Now, both you, Mr. Kasolo, and Ms. Mirembe have said that there is no legal framework for the arguments that you have put before us. How then do you propose us to decide these issues in the absence of the law? That's the first question. I think that one is open to any one of you. You can respond to that. The second is in the area and trying to understand, if I may, Mr. Masolo, your argument with regard to discrimination. And it is your argument that the discrimination is based on differential treatment, amongst others, between the young lady and the perpetrator. And when asked what you thought would be the correct way to manage it, you said, if the boy had also been dismissed, then it would have answered the question of differential treatment. Is it therefore your argument that in order to negative differential treatment, it would have been sufficient for the boy also to be dismissed, and therefore also, like the girl, not continue with his education. Is that the argument that you're putting before us? I have an issue with remedies, Madam Mirembe. What is it that you want us to do for your clients? You have consistently argued the case for the respondents, but you have not offered outside that what your remedies are. For example, declaration that there has been a violation. Is it your argument that therefore the girl should be allowed to return to school? Or you just wish us to provide declaratory reliefs? I don't know if you are asking us for specific reliefs or declaratory reliefs. I would like to know that. And considering that you have also acknowledged that Muemba has cultures, okay? Muemba has societal norms. And this court must decide in line with those aspirations and norms of the people of Muemba. How do you reconcile your arguments with the powers that are given to this court? Is this a legal question? Or is this a political question? My Lord Chair, those are the questions I had.
Thank you. I think we'll take the others and the answer once for all.
Yes, I only had one brief one. You concluded by saying that each party pays their own costs. Aren't you interested in costs? Well, was that your instruction from your client? Maybe you can give some brief reasons why you made such a prayer.
Thank you, Lord Chair. One, I think, let me restrict myself, given the time that is left, restrict myself to only one question. I had already asked about that question. My brother, Justice Kiawire, also came in and said a lot about it. But let me ask this very direct question now. In light of your submissions, generally, in light of your submissions, you know, you're saying you want, the perpetrator, the male student also should have been also expelled. How about both of them remaining in school? I just want to hear your views on that one. In light of all your submissions and your prayers, at the end of the day, your entire case. Thank you.
Okay. So I will just, there is a question that just Kiriawire asked about the norms and aspirations. You make it seem like your client, the only option she had was to do an abortion. Did she have any responsibility or other options, for example, keeping the pregnancy? Was that also an avenue? And do you think she owed responsibility to herself? Like she didn't have to go for that party? She didn't have to drink? Does she bear any responsibility, or all the responsibility is on the state? I just Kiriawire asked it in other words, but I want to raise that also, and you're free now to respond.
Much obliged, Your Lordships. I'll first respond to the question of how do we want the court to proceed if there is no legal framework. It is our submission that, one, the legal framework that exists is restrictive in nature. Section 152 of the Penal Code Act allows for women in the state of Muwemba to abort in instances where their life is at risk. But the appellant's submission is that under Article 14, Clause 2 of the Maputo Protocol, that the state is bound by, it provides other instances in which women can access a safe abortion. Instances of rape, incest, defilement, and fetal anomalies. It is therefore our submission that the framework that is in the state of Muwemba is restrictive.
Yes, Mr. Masolo, you remind me of another point. I'm sorry to come in again, but it's important for us our jurisdiction and what we can or cannot use. You have referred to us many conventions, many treaties. How are they justiciable for this court? I would like you to address that.
Much obliged, my lord. In response to that question, it is our submission that, one, the international treaties that have been ratified before and by the state of Muwemba are binding on this court, as they are also binding on the state of Muwemba. Regarding the issue of discrimination and the expulsion of Muyodi vis-a-vis the counterpart that raped her, it is our submission that Davis perpetrated rape. If the university was to leave him at school, it would be a miscarriage of justice. It's therefore our submission that he should have been dismissed. However, in the state, regarding Muyodi, it is our submission that dismissal of girls based on their pregnancy is discriminatory and unjustifiable. It is therefore our submission that her dismissal was unlawful. Regarding the question of whether it is a legal question or it is a political question, it is our submission that the question before this court is a legal question. Whereas the respondents may submit that it is a political question in order to evade responsibility, it is our submission that in instances where actions of the executive violate rights and freedoms of people in the state, then the court can come in to hold the state accountable. Your Lordships, I'll now yield the floor to my co-counsel to answer the rest of the questions.
Much obliged, Your Lordships. In response to the question of the social context or cultural context of the state of Muwemba, while the appellant do recognizes this context of the state of Muwemba, international law requires states to navigate through this cultural and religious context to ensure that such contexts do not limit or create barriers for women to access safe abortions. And therefore, in this case, we recognize that the state of Muwemba or these religious institutions have the right to exercise their religious doctrines. However, they have to determine they have to balance between the right to religious freedom and the right to sexuality education. And in this case, the appellant submits that since I beg your pardon. The appellant submits that since the religious freedom that was being exercised by the religious institutions was contravening essential rights like the right to education of the citizens of Muwemba, then the state had to take further steps to ensure incorporation, like sensitizing and educating these faith-led education boards about the dangers of not teaching sexuality education. And by the state failing to do so, it failed to ensure equal access to the right to education for all its citizens. Then in response to the question of whether Muyodi bears any responsibility and whether she was capable of keeping the pregnancy. In response to that question, my lord, all individuals deal differently with different circumstances. It was indicated by the African Commission, its General Comment number 2, specifically paragraph 37, that forcing a woman to carry a pregnancy as a result of rape constitutes additional trauma that in turn affects her mental and physical health. In this case, since Muyodi was a rape victim, forcing her to carry this baby would be detrimental, and given the other suffering that she had gone through, like being expelled from the school and also being faced with stigma from the society. Therefore, we submit to this honorable court that the available option, as also permitted by international law, was to grant her therapeutic abortion, and in this case, emergency abortion care. And in regards to the question of what we ask from this honorable court, we ask for declaratory reliefs alone and not, we ask for declaratory reliefs. We ask for declaratory reliefs from this honorable court. In regards to the question as to why we ask for costs to be borne by both parties, the appellant submits that since we've already been granted costs under the High Court, we request that this honorable court finds that both parties bear their costs to these proceedings. I submit.
Much obliged. If it may please this honorable court, I am Kamkama Susan for purposes of court record, the Attorney General of the Federal Republic of Muemba, and I am representing the respondents in this matter. I will first concede with the statement of jurisdiction as by the appellants, and they were also provided under paragraph 7 of the facts, which stated that Articles 112 to 127 provide for the courts in the Republic State of Muemba, and they stated that the Supreme Court is the final appellate court and can hear all appeals from the courts of appeal and other courts. With that, I beg to bring to the attention of this honorable court the facts before this court. The second appellant procured post-abortion services from Light of Grace Medical Center, which were denied. This came to the notice of Pokot University, which suspended and terminated her scholarship on grounds of indecent conduct, and she later brought a suit under the High Court, which was ruled in her favor. However, due to the dissatisfaction of the respondents, they appealed to the Court of Appeal, and the Court of Appeal ruled in favor of the respondents, and due to the dissatisfaction of the appellants, of the respondents, they appealed to the Supreme Court, hence the appearance of this case in this honorable court. I'm going to be using, we've been granted 30 minutes of this honorable court's time, and I'm going to use 15 minutes to respond to ground 1 and ground 2, and my co-counsel will use 15 minutes to respond to ground 3 and ground 4. With that said, I beg to proceed. The ground 1 was that court had in law, the Appeals Court of Muemba had in law and fact by holding that the failure of Light of Grace Medical Center to provide Muyodi with sexual and reproductive health services during her state of emergency did not violate her right to health, thereby did not violate her right to health. Your Lordships, Indeed, the failure of Light of Grace Medical Center to provide Muyodi Juliana with sexual and reproductive services did not violate her constitutional right as alleged by the appellants, because Article 22, Article 22, Clause 2 of the Constitution criminalizes the termination of the life of an unborn child, and Section 152 of the Penal Code Act of Moemba, Cap 128, under paragraph 9 of the facts, it also criminalizes the termination of a pregnancy, with an exception where the mother's life is at risk. Your Lordships, I will first deal with the exception as discussed by the appellants, that the mother's life was at risk. Your Lordships, the mother's life was not at risk. It was only at risk after her intention to terminate the pregnancy, after taking a quick fix pack that was intended to terminate the life of the unborn child. And my Lord, the appellants are depending more on the rights of Muyodi Juliana, however, forgetting the rights of the unborn child provided for under Article 22, Clause 2, which also grants an unborn child the right to life. They are looking at the necessities of Muyodi at that particular time, however, forgetting the rights of the unborn child. Furthermore, the Religious Institutions Regulations Act of 2003, under paragraph 14 of the Acts, gives authority and mandates private service providers to adhere to their religious policies and doctrines. It's on this note that I bring to the attention of this Honorable Court that Light of Grace had all rights to practice their religious doctrines and policies as provided for under the Religious Institutions Regulations Act of 2003. Your Lordship, in the case of Sharon Dimachi and others versus Makerere University, a constitutional appeal number 2 of 2004, Justice Katumba, as he was then, stated that, Chitumba, much obliged, I beg my pardon on that. Justice Chitumba, as she was then, stated that, if I may read verbatimly, that if I invite you to my house to live according to if I invite you to my house under specific conditions and you accept to do so, you will be held to be out of order if you subsequently attempt to replace the conditions with those which suit your own peculiarities. Your Lordships, the act of Muyodi Juliana going to Light of Grace Medical Center impliedly meant that she had agreed to follow the policies of the hospital, which were clearly stipulated in paragraph 23 of the facts, that Light of Grace Medical Center is a law-abiding institution and upholds its religious policies and doctrines. And it's on this ground that I submit that the refusal of Light of Grace to provide Muyodi with post-abortion services was not at any one point a violation of her constitutional right. We all know that abortion is criminalized, and hence, if the Light of Grace Medical Center was to help Muyodi or give Muyodi post-abortion medical services, would amount to abiding and abetting to commit a crime, which is against the laws of the Republic of Moemba. Furthermore, Muyodi Julian had rights to go to other hospitals in the state of Muemba. The appellants are alleging, the appellants are basing their submissions on the secular state of Muemba, which is true, it is a secular state, but however, forgetting Article 29, Clause 1, Paragraph C, that provides for all persons to, if I may read, all persons have a right to practice I will paraphrase, all persons have a right to practice and any religion and abide to the policies and doctrines of that religion. And so it's under the Constitution where the Light of Grace Medical Center is allowed to practice its policies and doctrines or, in accordance to their medical service provision. I will go ahead and discuss. In conclusion, however, I submit that this appellate court will find that the refusal of Light of Grace Medical Center did not violate Muyodi Juliana's constitutional rights, and I pray that this honorable court dismisses the allegations of the appellates and upholds the decision by the Court of Appeal. I would go on and proceed on ground number 2, which states that the appellate court of Muemba erred in law and fact by holding that the unlawful dismissal of Muyodi from Pokot University, a government-owned institution, based on her pregnancy and its termination, did not violate her right to the highest attainable standard of physical and mental health. And mental health. Your Lordships, it's not the obligation of a university to provide mental and physical health services, because this is an institution that is aiming at giving the nationals the highest attainable services as regards to education and not to mental and physical health. Furthermore, Article 30 really provides for the right to education. However, it does not guarantee the students to enjoy this right while abusing the policies of the institution. Under the same case as earlier mentioned of Sharon Dimanche versus Makerere University, it was held that the right to education must be enjoyed in accordance with the regulations of the institution. Article 43 does not also provides that in the enjoyment of the rights and freedoms prescribed under the Constitution, no person shall prejudice the fundamental or other human rights and freedoms or others or the public interest. I repeat, the public interest. The actions of Muyodi Julian to terminate a pregnancy were against public interest. Leaving Muyodi Julian in school with her pregnancy would eventually would be taken by other students that being pregnant in school is acceptable, which is not acceptable. And more so, the termination of the life. This is the abuse of a constitutional provision under Article 22, Clause 2. Article 126 of the Constitution also provides that judicial powers comes from the people and must be exercised by established courts in the name of the people, conforming to the law and the people values. Your Lordships, the people values we are talking about are the rights of they also include the rights of the unborn child. And termination of a right to an unborn child does not give a right to Muyodi to be granted her right to education, because a right to education is not a non-derogable right. It is not absolute, and it can be taken away as provided for under Article 43 of the Constitution. And it is on these grounds that I pray and submit that this honorable court finds that the allegations made by the appellants that the unlawful dismissal of Muyodi was based on discriminatory intentions. I beg my pardon on that. It's at this point that I pray that this honorable court finds the allegations by the appellants that Muyodi was expelled on discriminatory intentions not true, and uphold the decisions of the Court of Appeal that Muyodi Julian was instead dismissed on grounds of misconduct and dishonoring the institution's regulations and policies. If I'm of no more indulgence of this honorable court, I beg to submit. I yield the floor to my co-counsel to proceed on ground 3 and ground 4.
Your Lordships, if it may please this honorable court, my name is Marvin Ainiviona, and I'm going to represent the respondents to handle it. Yes, and I'm representing the respondents handling ground 3 and 4. My Lord, I would wish to first state ground 3 and 4. Ground 3 clearly states that the failure of Muwemba to put in place laws and policies that protect young girls and women from unsafe abortion, contributing to the high mortality rate of 8 deaths per day, violated the right to health and life of its citizens. Ground 4 as well clearly states that the failure of Muwemba to take steps aimed at ensuring equal access to education and healthcare services for all people, irrespective of their religious beliefs and cultural affiliation, is a violation of the Constitution of Muwemba. My Lord, the literal meaning of the word failure is that the state has not done anything in regards to what they might be alleging, the appellants. My Lord, I am going to handle issue 3 first, and I am going to handle it in 3 segments. Number 1 will be public morality question, as stated in paragraph D of the facts before this court. 2 will be progressive realization, as clearly opened up in paragraph C of the facts before the Supreme Court. Then 3 will be the political question doctrine, which is also put out in paragraph B. My Lord, in a very recent decision, Dr. Businje Kabumba, while appraising the Constitutional Court's decision on no-fault divorce in the state and expunging the ghost of Innocent Ngobi Ndiko, the lead justice, Helen Obura, who was the lead judge in this case, quoted Article 126, which provides that for judicial power to be established or exercised, it must be in consideration of the norms, values, and aspiration of the citizens of Uganda, which goes on to also say that it also requires that it is exercised in accordance with the law itself. So it does not stop at the other pretext. My Lord, this clear upholds democracy in the state. My Lord, if I may proceed, Article 37 of the Constitution, which guarantees the right to belong, enjoy, practice, and promote any religion in community with others, also has a same attachment to Article 126. In this case, it was reached on board after the Interreligious Council, which actually represents the majority of Ugandans, close to 94.8% maybe, that they agreed with court that appraising no-fault divorce in Uganda then would lead or would destabilize the cultural rights of the state. My Lord, in the instant case of Attorney General versus Susan Chigula and 417 others, while upholding the principles that were in that case, court also went on to look at the individuals that enacted this constitution and why was it regarded the same. Is because of the norms, values, and aspirations of the citizens of the state. My Lord, it is very clear in the facts that we have at hand. Article 3, which provides that the state of Muemba is a secular state that accommodates religious influences in a pluralistic society. My Lord, the exemptions under the Religious Institutions Act of 2003 exist to balance rights without violating Article 21, which still upholds democracy and also cures what is in paragraph D of the facts before the Supreme Court. My Lord, paragraph D as clearly states that the Federal Republic of Muemba had to ensure that people maintain the high levels of morality using the means available to them through the religious and cultural ethos, regardless of whether it is a secular state or not. So while administering justice, we now go back to Article 126. Then the norms, values, and aspirations of the people must be a core regard, as the appellates must not. My Lord, if I may move on to the next segment of argument, which is the aspect of progressive realization provided for under the International Covenant on Economic, Social, and Cultural Rights, which was still ratified by the same state pursuant to Article 6 of the same constitution. My Lord, the move by government to allocate 5% of the national budget depicts the aspect of progressive realization, meaning that the government has put up a move to ensure that citizens achieve sexual reproductive health. My Lord, the state also took a step to ratify international instruments that the appellates refer to. I hear the talk of the Maputo Protocol, the International Covenant on Economic, Social, and Political Rights, which shows that these international instruments have been ratified by the same state. My Lord, it is very clear, and if I may allow this quote with a case of Center for Health for Human Rights and Development versus the Attorney General and National Medical Stores. The court adopted the reasonableness test, if I may quote it ipsum verba. The court adopted the reasonableness test from South African jurisprudence to evaluate the state's actions. Justice Sinjiza noted that ultimately the court found that while challenges existed in medication distribution, the state had taken proactive, targeted and measurable steps to address these issues. My Lord, the judge went on to re-emphasize that it would be unreasonable to fault government when it had actively engaged in problem solving and resource allocation, which is clearly put out in our facts at hand. This approach demonstrated that courts recognized the complexities that come with resource-constrained governments while affirming the role in upholding the constitutional rights of the citizens. My Lord, this clearly affirms...
I will ask you the same question I asked the other side. What weight do you want the court to attach to that case?
My Lord, much obliged. We, as the respondents on that issue, we really want court to agree together with the appellates, to agree that government has put on measurable steps that achieve the doctrinal aspect of progressive realization in achieving the states and the rights of the citizens, because it has put out resources and it has also enacted laws in consideration of the same. Much obliged, my Lord. If I may proceed. We also note that this as well has been a persuasive case to also lead court to agree with that decision. My Lord, if it may please this honorable court, in the facts we have at hand, this state operates on very few resources. It was actually well quoted that the state does not operate on a bottomless tank of resources. So it simply means that the state's allocation of the 5% is in prioritization of other sectors, which also shows that the health sector has been prioritized. My Lord, if it may please this court, I may go on to segment 3, which is the political question doctrine. My Lord, the Black's Law Dictionary that I may use to define what political question looks like, it refers to the political question as a question that court will not consider because it involves the use of discretionary power by the executive or legislature branches of the government. My Lord, it should be taken into account that the legislature pursuant to Article 79 of the Constitution is mandated to enact laws. My Lord, the executive in Chapter 7 goes on to implement these laws. My Lord, pursuant to the facts at hand, it was very clear when the state put up the amendment proposal 2021 bill, which was supposed to put in place other mitigating factors as much as abortion is concerned, which was rape, fetal anomalies, and other incidences where someone can abort on the same. It really shows that the government has put up an effort still on realizing some of these aspects. My Lord, if I may persuade this court with the Indian liquor ban case of 2017, the Supreme Court of India banned the sale of liquor within 500 meters of the national and state highways, a decision that was argued to be an overreach into an administrative matter with the economic consequences not on the judicial one. My Lord, this is a clear depiction that some of these issues are regarded to the executive or legislature to do their role, and court really is restricted from the same. My Lord, if I may proceed to issue 4, the government through the Ministry of Education, Human Capital Development has issued a national framework for sexuality education in 2016 as brought on board by the appellates, which was placed in 9 regions of the state of Moemba, which simply shows that the government is still making a move to ensure that sexuality education is out there and young girls like Muyodi get to understand what it then means with sexuality education. That is a move that is also under the aspect of progressive realization. My Lord, Article 12 of the International Covenant on Economic, Social, and Cultural Rights requires non-discrimination but permits cultural consideration in the aspect of progressive realization. This goes on to open us to the fact that while putting in place these rights of health, then it should also be considered that the norms and values are still in consideration. My Lord, in Center for Health, Human Rights and Development versus Attorney General of Uganda Court, Uganda Constitutional Court 2020, courts deferred to policy discretion in resource allocation, forcing uniformity on faith-based entities, which would infringe religious freedoms under Article 8 of the African Commissions on Human and People's Rights, and the government's 28% education budget ensures overall access to the regional variations. My Lord, it is still on the same aspect of progressive realization that the state has put in place an effort to ensure that people achieve anything in regards to sexuality education. My Lord, in conclusion, we acknowledge the vitality of protecting human rights, especially the rights of women, the rights of young girls, but we also consider the complexities that come with implementing some of these rights. And the government has at least put up an effort to make sure these have been put out. My Lord, as I conclude, we thereby pray that this case is dismissed and the decisions of the Court of Appeal are upheld by this honorable court. My Lord, if it may please this court, this honorable court, I wish to submit.
Thank you for the Attorney General, Ms. Kamukama and Mr. Ainabjona. Madam Kamukama, if I may, you suggest to this court that what is it? Good Grace? What is the clinic? Sorry?
It is Light of Grace Medical
Light
Center.
of Grace. Light of Forgiveness Clinic. Had the constitutional right because of its religious stance to send away the girl. That is your position. I wonder if it is a complete position, because as a medical facility, did it have, in your view, a duty of care that transcends its religious stance as a medical facility to provide medical care? I hope I'm clear on this one. It's a medical facility, and as a medical facility, I would imagine that it has both an ethical and professional duty of care to respond to an emergency, failure of which could lead to tortious liability. I want you to reconcile that with what you have already argued before us, that they had an absolute right to send away the young lady. The other question that I have for you is, in terms of providing the highest standard of education, as you argued, that is the obligation that the government needs to see, that educational institutions do. They provide the highest standard of education. I wonder whether that is in contradiction to, or is diametrically opposed to, the provision of healthcare and physical education. Are you suggesting, therefore, to this court that the highest standard of educational discourse is purely academic? I would like an answer to that one. Also, I have many questions. You argued very widely on Article 126, the norms and aspirations of the people of Uganda. Are they static or are they evolutionary? I did not hear you, when someone talks about a norm, does it remain or is it evolutionary? Does it change as society changes? I think that would be useful to us to understand. Mr. Anyebuyona, you structured your presentation to us under 3 heads, for which I thank you. And you gave us a definition for the political question. And I'll come to that. But you did not give us a definition to what public morality is or what progressive realization is. I think that would be very useful to us to know. But you gave us instances of how the government has released 5% of its resources towards these areas you have been arguing about. But I wonder, you also said that it was in compliance of, I think you refer to it as Article 6, such as Article 60 of the Muemba Constitution, which actually makes international treaties justiciable within the state of Muemba. I think that was paragraph 6 of your facts. But I wonder, for example, the ISER, International Covenant of Socio-Economic Rights, okay, for example, was passed in 1966, which is 59 years ago. Are you able to reconcile that passage of time with progressive realization of the rights that are indicated therein? And whereas you also mentioned in great detail, you did not address this court at all, and probably we need to give you the floor on this one, that what has the Federal Treaty Oversight Commission, which is provided for under paragraph 6 of your facts, what has it done to ensure the progressive realization of rights as it is its mandate? Finally, on the question of political question itself, you referred to us, I know it was Madam Kamukama who referred to us, the Serhab and Attorney General. But I wonder, sir, if you're aware about the decision of Serhab, the appellate decision of Serhab versus Attorney General in the Supreme Court of Uganda, where it was decided that the political question doctrine should not be blatantly used as a cover to deny to deny clear obligations that the state must do. I have not heard from you, apart from giving us the 5% statistic, what is the program that was envisaged by their lordships in Uganda? And you remember, they gave a decision where they required them to come back and confirm the program as to progressive realization of those rights. That's, I don't know, the weight that you gave to the political question seems to have been absolute. I wonder if you believe that the Supreme Court decision on Serahab versus Attorney General in Uganda should be persuasive to us as well.
Yes, thank you very much, Council, for the respondents. I only have, I think, 2 questions because my brother has asked you one. And either of you could answer this one. From your facts, then the second question, we are pushing to say criminalization is even unconstitutional, criminalization of abortion, and the rest of it. That is what I'm saying. And you're saying, do you need, should I repeat or it's recorded? Okay. You had the first question. The second one, you are saying the state is taking some steps anyway to pass legislation and doing so many other things. And we still have the fact that abortion is criminalized anyway. So my question is, can the state criminalize and at the same time regulate? Can those two work together? And just to add on to what my brother said, very briefly, you emphasized aspirations, cultural norms and values should be respected according to the Constitution. Is it the aspirations of the people of that state that women should continue dying from abortion? Because it's clear, the statistics are on the table. Women are dying from unsafe abortions. Is that the aspiration of the state and the peoples of the state of Muwemba? Thank you.
My Lord, do you?
Thank you, Lord Chair. The first one, what are the obligations? And I think this is the appropriate question. What are the obligations of the state? What are the obligations of the state you represent in as far as sexual and reproductive health rights are concerned? What What is the interplay of the international treaties that Muwemba has ratified vis-a-vis its domestic laws and moral values? it appears to me that the domestic laws take precedence. Is that the case? You also stated in your submission, Attorney General, that the university does not have the obligation to ensure mental and physical health. Its focus is on education. So should I be assumed right that I can be carried into your lecture rooms on a stretcher with several drips, and for you, your concern would be to impart knowledge, and you'd never be concerned as to why I am being wheeled into your lecture room on a stretcher? Then you talked about I think you meant derogable rights, because the non-derogable rights are those that can never be removed. So, according to you, Attorney General, can the derogable rights be removed or taken away anytime? You'll wake up today and say, today you're not going to enjoy your right to information. Is that the case? And it appeared to me that you invoked a progressive realization under the International Covenant on Economic, Social, and Cultural Rights when it was convenient to you. So we would want you to address this court on the entirety of the definition of progressive realization. Your submission appeared to be one-sided in as far as progressive realization is concerned. Complexities. When you mentioned complexities in as far as the enjoyment of human rights is concerned, according to you, can human rights be negotiated? Thank you, Lord Chair.
Thank you. My question is about the male in this equation. Appellants were saying he should have been expelled as well. So if we go a little deeper than that, in the comprehensive sex education, of course we are dealing with the female. Is there an obligation for young men to undertake this sexual reproductive education? Does the state have a duty to educate both sexes on this? Two, this matter seems to have a criminal element. Are we sure there was a rape? At what point can we say actually the girl was not understanding and therefore she was raped? Has the state taken measures to investigate the actual thing? Thank you. You can go ahead and the actual thing. Thank you. You can go ahead and respond to the questions. Respond to the questions.
How much time give them in view of the questions?
With mental and health services. Your Lordship, I did not and health services. Your Lordship, I did not actually say the university can completely not give some mental services to Miodi, but what I was actually regarding to is actual medical services, because for actual medical services, I strongly believe we attain them from the hospital, because the university will eventually benefit of your life. Furthermore, I will also answer the questions that were relating to the norms of the state being static. Your Lordship, the norms are not static. They change as time passes by, but however, they still change in accordance with the provisions of the law. And them changing doesn't mean they will actually allow some some crimes to be done by the nationals. And that's why I still strongly believe, regardless of the changing norms and aspirations of the people, women are still not allowed to terminate the lives of an unborn child. And I also had a question between the mothers at more. Your Lordships, these lives are all equal lives and they are all protected under the Constitution. However, my argument was terminating another person's life, and the refusal by light of grace to give her post-abortion services was for their policies of abiding to the laws of the state, because aiding and abetting is also a crime. And if Light of Grace had done this, it will eventually make them lawbreakers under the law. And so the refusal was not saying that Muyodi's life is not important, but rather it was, she was already against the law, and giving her these services would amount to aiding and abetting to commit a crime. Furthermore, on the case of discrimination, I will persuade this court with the case of Lee versus Asher Baking Company and others, a 2018 case, where the respondents in this matter refused to bake a cake for the appellants because it was a single-sex marriage. However, the court held that the refusal of the respondents to bake a cake for the appellants, it was not on grounds of discrimination, but it was on uplifting their beliefs that what the appellants were doing was actually was inconstitutional, and it was against their beliefs. And to answer, much obliged, I beg to submit.
Much obliged. You wish to know 3 minutes? 3 minutes. Okay. My lord, the time is quite short to answer all the questions. But regardless, I just want to start with the most important thing. Well, the Constitution of Muemba is the grand norm, and the international instruments are subject to the grand norm. If the Maputo Protocol, for example, was stating that abortion can be extended to cases of rape, incest, and the rest, and the Constitution provides for this, for only rape, then that is what we then follow. My lord, on the aspect of public morality, if I was to give a literal meaning of how public morality looks like, it refers to the shared ethical principles, values, and standards of rights and wrong behavior that govern a society's collective life. My lord, the legal principle of progressive realization looks at particularly the principle requiring states to continuously improve the enjoyment of rights by citizens. And that is why, as the respondents, we also look at the aspect that the government has put in place certain measures to ensure that citizens go on to enjoy their rights. And when we are looking at the aspect of progressive realization, we also look at the capacity of the states. What resources do the states have? Does it simply mean that we should allocate 80% of our budget to security and ignore health? That is not the aspect. But we look at the prioritization of which sector is important and make sure that we look at that sector and award it what is then important. My Lord, if I may also go on to proceed on Article 126. We are not simply saying that the state, that Article 126 only provides for norms, values, and aspirations of citizens. As I was submitting, I went on to say that it is also in accordance with the law itself. Much as the norms of the people are important, but they are also subject to the law in context. My Lord, I think my time is fast spent. I beg to submit.
Much obliged, Presiding Judge. I'll now proceed to submit in rejoinder in 5 minutes. First, regarding the right to religion of Light of Grace Medical Center, it is our submission that we do recognize that these hospitals within the state of Moemba have the right to practice their religion. However, in instances where a patient's life is at risk, at the very least, these medical centers should tend to these patients, but at the very, very least should refer them to other hospitals that can tend to them. Secondly, we do also recognize that the right to education is exercised in light of the rules and regulations that these different institutions have. However, if these rules and regulations are being applied on the need to change and follow the times. Regarding the issue of progressive realization, first of all, requires states to utilize their resources to the maximum. And in the instant case, the state of Moemba is only issuing and allocating 5% of its budget to health. But also, the principle of progressive realization requires states to fulfill minimum core obligations that entail passing laws and policies to ensure the realization of these rights. Regarding the political question doctrine, it is the appellant's submission that pursuant to the case of Sehad versus Attorney General by the Supreme Court at page 25, that this principle does not shield the executive and parliament from judicial scrutiny as to whether or not they have exercised their mandate in line with the Constitution. It's therefore our submission that this court still has the power to ensure that the state has exercised its duty in line with the Constitution. Regarding the issue of sexuality education, it is our submission, and we do agree that yes, the state has put in place the sexuality education framework. But if the norms and aspirations of the people are prohibiting this framework from being implemented in the different institutions, then it still has a duty to sensitize the people on importance of sexuality education. And lastly, regarding the Constitution vis-a-vis international treaties that have been ratified by the state, it is our submission that pursuant to Article 26 of the Vienna Convention on the Law of Treaties, that a state cannot rely on national laws to abdicate its duties under international law. Presiding Judge, Your Lordships, it's therefore our submission, and we pray that this court upholds the ruling of the High Court of Moemba. The appellant submits.
Thank you very much. Thank you very much, counsel, both sides. Thank you very much, rest of the courtroom. You have observed the decorum of the court, and let's give ourselves a hand clap for behaving very well. And for the counsel on both sides, I think they have submitted very, very authoritatively, and they have done a very good job. Let's appreciate them. We'll now allow the bench to reach an appropriate time. We'll come back and hand it over so that the organizers can then give the final verdict. Thank you very much. You're supposed to bang the gavel, then we can get up.
Hello, everyone. I don't know if they need to take a breather. Okay, let me give you 5 minutes to get over it. To get in and out of the mood. Feel free to pause for pictures where you're seated. Make sure you don't leave without a picture taken of you or your team. Because if you don't take the pictures, then why did we bring the people around? So take the pictures with whoever you want to take the picture with. It's okay. In the meantime, before I say what I've come to say, is Kojo Sarah here? And Chitimbo Alison Faith. Are you also here? You left some things in your room. Kindly come and pick them when you are checking out. Which means I hope all of you checked the rooms before you left, because some of you might have left your personal belongings there. So you left some things in the room. Kindly come and pick them. That's 1. 2, I hope you have all checked out of the hotel. We had up to midday to do that. It's already midday, a few minutes past midday. I hope you have all been able to do that. 3, I'd mentioned earlier. No, let me first say thank you to these teams for fighting. You guys put up a spirited fight, and I'm sure everyone here was listening in and enjoying the discussions. It's not easy as judges and you fight up like that. So kudos to you guys, and may the best team win. So I talked about feedback forms earlier for those who are here in the room on time. So I'm just going to share this with you all, and you can use maybe around 5 minutes to fill them in, and I will come and get them from you. So I'm going to put them on each table. Kindly give us the feedback. Again, if you don't give us the feedback, we shall not know how to make the Moot a better experience for you. Because we are not the ones competing, you are the ones competing, and we are merely organizing. So take the time to read. It's a short form, just 1 page. Take the time to read through and give us feedback so that we can be able to pick the lessons from this Moot for the Moots to come in the future. Kindly give us that feedback, and if you have anything else you want to say, not on this form, kindly come on and reach out. But I would encourage you to write it here, because once we document it here, it's easier for us to follow up, even when we have a Moot coordinators meeting. So kindly do that. And as we wait for the judges to come back, once they come back, they are going to give their feedback, and then they'll announce for us the winning team. Winning team, okay, the first team and the second team, who are both going to be awarded or rewarded. Yeah, I'm going to request for volunteers on each table to just help me get the feedback forms. But in the meantime, I think we have received this particular complaint since yesterday. I don't know if it's a complaint or an issue or a query about judges and the marks they are giving, and how some judges give a lot of marks and then some give very little marks, which affects the what? The scores of a team. I think I've received about 4 or 5 people complaining, which somehow takes me back to coordinators. More is quarreling with coordinators. Every time we have the Moot coordinators meeting, we communicate changes that are going to be made. We communicate the new things on ground. So we started this particular change last year. So previously, I'm having a score sheet here for the preliminary rounds and the semi-final. And this is preliminary rounds. So previously, the judge had the full discretion to give marks as and when. For example, if you appeared before me as a judge in my courtroom, I could be a judge who doesn't mind the marks, and maybe I'm quite fair in giving marks. And to me, if team A performed very well, I'll give them an 80%. And if team B performed poorly, I'll give them a 70%. But maybe you could go to Judge X in another courtroom who is a bit too academic, or, for lack of a better word, mean. We've all been through law school or done coursework before, or even examinations, where some lecturers are just, for lack of a better word, mean with their marks. Or for them, if you're very good, their very good could be a 70 or a 60. Yet somebody's very good could be an 80. So we received that feedback almost 2 years ago. And what we did was, when we spoke to students, the recommendation we got was, can we give the judges, can I call it a schedule or a guide for giving marks? For example, if they're awarding marks for legal arguments, the maximum on this score sheet is 30 marks. So we gave them a guide and told them, if according to you, a student is weak, please give them between 0 to 6. If a student is fair, give them 7, between 7 to 12 out of 30. If a student is average, according to you, give them maybe between 13 to 18. And if they are good, give them 19 to 24. And if they're excellent, give them between 25 to 30. So that is as far as we go, because you see, a judge still retains the discretion to give you marks as and when. But with this guide, you find that nowadays they are guided. So if a student or a team is very good to them, very good in terms of their arguments, they cannot give you a 12 out of 30. They cannot give you 6 out of 30. They're going to give you between 19 to 24 out of 30. The only issue still comes to the judges who still have the power to give as and when. For example, if I am Judge A and Masolo is very good, my good, I might decide to give him the 19, which is the starting of good. You get? To me, I might decide to give him 19 out of 30. Whereas Judge B, if they found Kamukama very good, will say, let me give her the full 24 out of 30. Now that is where, again, sometimes the issues come in. But you see, we cannot control judges and tell them, give this, or don't give that, because they have the power. Are you getting me? So we had an issue yesterday where a judge met particular teams, and one team impressed him very well, and he gave the marks. But the marks was given, even though they were good, they are 19 out of 30, 20 out of 30. That's why some teams end up having 89, others, even though they are good, they have 70. But you see, even in actual practice, you cannot get over the discretion of the judge. Are you getting me? So we thought that with changing this or putting the guide, we solved the issue of some judges give too much marks and others give little marks. But it seems like the issue is still coming up because teams complain, and I understand their justifications for doing that. Someone said, we were the best in our courtroom. Like imagine you're in courtroom A, and the worst person gets 85%. And then in courtroom B, the best person gets a 70%. For us, we understand. I don't know what now we are going to do, because we thought by giving that guide, it was trying to tackle that issue, but now we're still coming up. Not when we're giving feedback, you you guys need to give us suggestions. What do you think we can do this? But even as you're doing that, remember a judge has the discretion to do what? To give you as and when, depending on how you have performed. Are you getting me? And I've been trying to take my time to explain to everyone who has come to me, because before, we didn't even have the guide. They would just come and give 20, 30 and all. But then when we had to guide them, that tried to keep within the time between the guide given to them. So if you have any idea or suggestion of how you think we can make it better, then okay, because someone already was telling me a particular idea that we should follow, that maybe we need to move from the hallmarks thing and follow the teams that have passed both rounds. But you see, that might also be a bit problematic, because team A, which maybe failed that first one, like first round, is going to come to you and tell you, but it is not fair that you have actually made me go out even if I have been able to pass. So maybe you can give us ideas of what do you think we need to do. But as you're giving us ideas, remember, a judge has that discretion, okay? We've guided them and they follow our guides, but they also have the power, because you cannot force somebody's good to be 19 out of 30 when they feel like their good is 24 out of 30. The judge still has the power to do that. So I feel like we are trying, but maybe if you have any other ideas, feel free to make the ideas and write for us that feedback in those forms. Then maybe when we are convening the next meet, because you normally go back and read through the ideas and see what's the issue. Again, like I told you, we used not to have quarterfinals before. You would come and compete 14 teams, and out of 14 teams, almost 10 are knocked off, and only 4 like go to the semifinals. And kids were like, not kids, students were like, students were like, it's not fair for us to come in and put our effort and time to compete, only for you to tell us, thank you very much, all 10 of you are what? Out. That's how we had to adopt the quarterfinals. So again, if you have any feedback or something which you feel is pressing your neck, just write it here, because if you don't give us that feedback and you go and say it was not this, it was that, then we shall not find ways of helping you. But want to tell us what you want, and if you complain about something, please give us an idea of how you want us to improve. Don't just say it's bad, but tell us what you want us to do to make it a better experience for you as the participants of the notes. I just had to emphasize that. If you still have a feedback form, kindly bring it to me.
Can you call me through Nachibuka's phone? Mine is going. Call me through Noel's phone. Mine is going. Hello, sir. No, we are not ready.
Hi, people. Hello, people. Okay. So, colleagues, so yesterday we said that we all have certificates to take, but I know on such a day, the moment the judges come in, when they announce the winner, you guys walk away. Unfortunately, we will not look for you to give you the certificates, and don't come claiming for it. So when the judges walk in and they announce the winner, we will give trophies to the winner and the second, I think. I made a first runner up. And then when the judges move out, we'll do the awarding of the winner and second runner up. We'll do the awarding to the judges. We will all go out for group photo. We usually take our group photo down on the stairs near the pool. We expect that after the stairs, however happy you are, you come back for the final session of your certificates. Is it okay? Is it clear? Please don't go without them. Is it clear? Okay, so we are here.
All right.
In the Supreme Court of Muwemba holding at Muwemba, Supreme Court Civil Appeal number 1 of 2025, Masolo Adrian, Mirembe Linda Namulema as the appellants, Kamukama Susan, and Ainebiona Marvin as the respondents.
Thank you very much. Good afternoon. How are you doing? Yeah, we are back with some comments. As you know, when you are in a competition, there is winning, but there is also taking lessons from the exercise. And in life, at our age, you realize that exercise is actually more important than whether you've won or you've come second or third. So their lordships are going to make some comments about what they saw and where they felt could be done differently, better, and so on. And after that, we'll go ahead and tell the council. I'm sure they're anxious to know which side carried the day. That is also an important thing. So the way we are going to do it, we are going to start with Justice Ida, then we'll go to Justice Gaswaga, we'll go to Justice Luswata, Justice Kiriawire, and then I will wrap up. So without further ado, Justice Nachiganda.
Thank you very much, Lord Chair. And to congratulate the teams on a job well done. Just a few comments. When we are arguing out our case, it's always very important to root our case in the legal standard, or your argument in the legal standard. To always start with the legal standard and derive your argument from the legal standard. For example, if we are dealing with the Constitution or with the domestic laws, you always start with the article of the Constitution of whichever jurisdiction you're arguing from. Then we were talking a lot about discrimination. If you claim discrimination, you have to clearly state the ground. And the grounds of discrimination are clearly stated in the Constitution. You cannot add to them, you cannot amend them. For example, you say somebody was dismissed based on their pregnancy, and that was discriminatory. So if you look at the Constitution, for example, of Uganda, it does not have discrimination on the ground of pregnancy. So you have to state the ground as stated in the Constitution. Avoid generalization of making of general or sweeping statements. I remember at one point I asked, is that an internationally recognized obligation? Because even the obligations of the state are set in the international legal regime. We all know the obligation to respect, the obligation to protect, and the obligation to fulfill. Those are the three obligations of the state. So all our arguments that are based on obligations of the state should be rooted in those three internationally and domestically recognized obligations. Yes, we also kept quoting the national objectives of the Constitution. I guess the question would be, are national objectives binding? So we also need to reflect on that. Are they binding? Are they justiciable? And also the issue of how are international laws operationalized domestically. The case scenario we had, was it a monist or dualist state? That they ratified the international laws, do they immediately become operational, or they have to go through a process of domestication? That's all, Lord Chair. Thank you.
Yes, let's give her a hand clap. Just Gaswaga.
Thank you very much, Lord Chair. First of all, I would like to thank you all not only the panelists, but all of you for taking part in this Moot competition. It's important that you are not left behind. Always ensure that you participate. I want to thank the organizers. I liked the subject itself, was very good, and it's unique in its own way, as you're about to realize, especially when you get to the field. And generally, I want to make some general comments because my sister has made some specific ones, which I don't want even to repeat. I just want to make some comments about the manner in which the presentation of the relevant cases were presented. One is about remaining on course even when interventions are done by the court. I must commend you for that. I saw how you responded. It is very important because, you know, this is a court setting and this is what happens actually in real life. As you are making your presentations, a judge will come in here and direct you this way. But from what I could see, you came in with your already prepared, you know, speeches, and it's not easy for somebody once there's some intervention, for them, you know, they are kind of derailed from what they've prepared. But how do you get back on course? So you did it very well, and I must thank you. I noticed that. Then the demeanor, your demeanor, and now I'm talking about the ones that we've seen. I cannot make a comment about what happened yesterday when others were presenting. The demeanor was very good, composure for all of you, even the language. You know, ours is a profession of courtesy. You know, you must be courteous all the time, whatever the circumstances. You must be courteous to your learned colleagues, to the court, and to everyone in the courtroom. If at all you want to have any exchanges, those are done rudely outside the court, not in a court. So that courtesy was there. You respected each other very well, and the court decorum was upheld and respected. There was a very good mastery of the law as well as the facts. I could see the facts flowing, and this is what we want. You've been given a brief. How is it going? You have the facts here at the fingertips, all of you. And then the law itself, the way you are citing it. I will say a little bit more about that a little bit later. I'm glad my sister has talked about the obligations. I shouldn't repeat. She has put it the way I would have loved it too. And that goes direct to the subject matter that we did. Three things which I just wanted us to look at as we look at the future. One is about teamwork. I want you to know that the practice of today and tomorrow, I should say, is about teamwork. We used to have one-man chambers, Gaswaga and Company Advocates. You ask, Gaswaga and Associates, you ask, where are the associates? It's Gaswaga himself. Where are they? He's the main man. Everything, it's him. That nobody's going to give you work. So teamwork is the way to go, and it just has to happen that way. I could see a lot of, for instance, and I could see the teamwork, even if we're not around, we could tell, you know, where a judge sits, we see a lot, and we take note. I could see, for instance, between the council, there was communication, a lot of communication, yellow sheets moving here and there. That means your mind, you know, you are on the same page. But also even from the audience, I could see some of you even from the facial expressions when your team was, you know, you could see maybe someone should have said this or has forgotten this and so on. Clearly, it was visible from here that there was teamwork amongst all of you. Nobody's going to stand alone. Nobody's going to give you work in the coming years if you're not going to work as a team. And I should thank the organizers for letting these people start practice teamwork right away. That's the way to go. The second one is marrying the law with the evidence. And then in the context of, you know, what is on the ground, applying the same in the reality and considering the realities on the ground. This is very, very important. You have to look at the laws, as you've cited them very well, and also the facts have said you mastered them very well. But what happens then is that for us, when we sit here, we expect you to bring your submission in such a way that the law is married together with the facts. You know, I should tell you that A lawyer's job is not to win, but you are called upon to present your client's case in a professional way. That is all. And how do you do it? Now, let me talk about the facts. It is up to you. Don't assume that the judges know the facts. However thick the volume, the brief may be, you have to find a way of summarizing them, capture what is important, what is relevant. On the side of the bench, we do our work, we know what to do, we read through the briefs, but we want you to bring those facts to us. So it should be you, your duty, don't assume. And I'm talking about what we are going to do in the future. So when you marry the law together with the facts, it becomes very easy for you to make your point. You cite the law, and when citing the law, also you have to classify them, the hierarchy. She has already talked about that, but the hierarchy. How are you going to apply, for instance, the Constitution, other acts within the legislations within the, but also the international instruments? How do you apply them? Are they applicable just directly, as she has talked about monism and dualism? Are they, you just apply them directly in the municipal or national courts? You see, those are very important. So I heard you citing them, and one of the judges asked one of you that, what is the weight of this case, for instance, yeah, and the magic word was one. But I also saw this side when they were asked the same question, I saw one of them moving a cheat to the other. I was able, because I have 4 eyes, to read the magic word on the cheat. I saw it at least. Don't blame me for that. And he got the answer and got back because he was a little bit struggling with the answer. I said, you know, so that is very, very important, the role. And then I want also to look at, there's an example, for instance, of the progressive realization of rights. So many questions came along within that area. But what lacked a little bit, and in the future we should look at it, were the realities on the ground. We are applying, but what are the realities on the ground, and what is there, and how are you applying that progressive realization of the rights? I will leave it at that. The last one I want to talk about is preparation. Let me tell you, never underestimate the power of preparation. Once you prepare anything, you'll get it right. That's why you see these musicians, movie stars, and so on. They go over and over something, very small piece, and eventually they get it right. And once you get it right, then even it builds your confidence. You know, it becomes like a song. I saw one of you making the presentation as if they were, I was going to mention the gender, as if they were reciting a poem. But a little bit of destabilization came in when a question was shot from the bench. And so it is important that you prepare. Even then, the council managed to recollect themselves and quickly came back on track. There are some small minor things that go with the presentation, with the preparation. You may think they are really small and ignore them, but they are very important because they enable you to present your case very, very well. For instance, time management, how making a roadmap for your presentation. AG here started off very well, and I liked it. I noted it. She's for the respondent, AG. The other one was the applicant. One would have thought that probably since the applicants are going fast, they should have been the ones, no, it was the AG because he's in charge of the bar and made the introductions. But even then, when each team stood up, again, there was some fresh introductions, and they made some pronouncement about their case, the roadmap, so that the judges know where you are starting, where you are, how you are going to take them, and where you exactly want to go. Our case briefly is this, just 1 minute is okay. Our case is like this and this, we are going to do this and that, this is how we intend to do it. And then you even share the time and the roles. And you say, I will start with, say, arguing ground 1 and 2, then my learned colleague will go on ground 2 and ground 3 and 4, and so on. So that we know how you are going to take us. Because even us here, we reset our minds as a court, and then there are certain things we shall expect. So we move in a very orderly way. With those brief of very many comments, allow me end at this. Thank you very much, my Lord.
Yes, thank you, Lord Chair. I will also join the panel to thank you very much for a job well done. It was a very good, pertinent question of issues, you know, current issues in Uganda as well. And I think the two sides handled their each side quite well. I have attended so many moots, and every time I attend, you see an improvement in the way students are handling these matters. Just a few comments. It is not always necessary to repeat the grounds. You kept reading them. The panel already has the grounds. We know them. Learn how to paraphrase certain things. Remember, you have been given very limited time. So you're going to spend a lot of time reading a whole ground verbatim, and it takes 5 minutes. And you have not even told us how you're going to resolve it. So learn how, we used to call it précis, for those who did literature, how to say something in briefly but concisely. Of course, it's good to first paraphrase it so that you keep remembering what the ground was about. Otherwise, you digress. I like the way each of you appeared to have little notes. You did not come with the whole volume trying to get things out of the record. And that is all part of preparation. Prepare very well because you have very limited time. And it also helps with systematic presentation to know I'm moving from this to that to that. I saw some struggling a bit looking for where the quotation is. If you can't find something, forget it. And because it will make you look disorganized. But if you've prepared your work well, it should help. It should help. So making notes beforehand is good. He's talked about the introduction. An introduction is very important. If you went to jurisdictions like in America, that, you know, opening statement is so important, and equally it should be important here because it sets the pace of what you're going to tell the court in brief, so that if you run out of time or for any other reason, the court already knows this was a lawyer who knew why they came to, what they came to do. In cases where you have to concede, some matters do so. Sometimes you're arguing something which is so obviously bad that it is going to distance the court. So for those matters where you can concede, you can say so, especially if I can say to the respondents that this is the situation, or it might be a fact by the petitioner. Okay, this woman committed a crime. Yes, because probably there's a penal code provision and there's a constitutional provision. And then you start from there. You are bringing the court to you that although this fact happens, but sometimes you might waste so much time to submit on something which is very obvious instead of conceding to it. Reliefs, I think we also raised it. My brother asked a question, what reliefs exactly? You are not very clear. What are you seeking? In this case, this was a woman who had been lost her right to attend a university and then to obtain certain reliefs in maternal health. Okay? So we are not too sure about what instructions she gave you because we are not there. But usually victims will be looking for relief. So what kind of relief are you getting for them? Of course, this was an appeal, and we are either to uphold or decline what the High Court said. So you could repeat what the High Court said, and so that the court is conversant with what actually this victim was interested in. And there was, I think, a comment on, normally this kind of litigation is public interest litigation. So bring it out that we are only not, it's not only this one person, but there are many. But at the same time, this one victim wanted this kind of relief. So even as you're advising the clients, the client might not even know what she's able to get from the court. So advise them accordingly that this is the kind of relief we can get from you. Then she'll tell you yes or no, this is what I'm interested in. Lastly, which is really nothing to do with the law, we've talked about decorum. Yes, we are happy with the way you presented yourself, the way you are talking to us. You managed to, all four of you could hold our eye, you know. You are not, you are not rude, but at the same time when you speak to the judge. I want to encourage you also the way you dress, the way you present yourself. And I'm sorry it might appear a little bit sexist, but try and present when you're coming, especially for important cases, so that the court is not concentrated on looking at what your hair looks like or what your dress looks like. Try and keep it nice and neutral so that they concentrate on your, yeah? Of course, if you're very untidily dressed, we'll even ask you to leave. But there are little things that you can do. You can keep your hair right down and off your face, for example, so that you might find a judge who gets distracted, and before they, oh, I didn't hear what she said or what he said because of the way you're dressed. It might be something small, but it's important. I think that is what I have to say.
Thank you. Let's appreciate.
Thank you very much, Lord Chair. I want to thank everybody who has been involved today in what you have done. Both sides. Congratulations, well done. Those who are jealous will not clap. I just want to ask a simple question, my Lord Chair. Today we have been working through a moot, which is a scenario of what happens in court. Just by a show of hands, how many of you have actually gone and sat in a court and seen what happens there? Just by a show of hands. So you can see, my Lord Chair, we are struggling to put up our hands. If you want to be good, I don't want that table. If you really want to be good at court, you need to go to court. Just, if instead of hanging out in the mall, you hang out in what? In court. Because this is the rest of your what? This is the rest of your life. We have court sessions running in magistrates' courts. We have court sessions running in the High Court, in the Court of Appeal, and Supreme Court. Even though you don't know anything about the case, just go and see. We call it the art of advocacy. Go and ground yourself in the art of advocacy. You cannot do that by just reading or watching, movies. You can't just do that. You need to go to the courts. You need to see how people present their cases. I think that's the first point I want to make. If you really want to be a trial advocate, go and see how it is done. You don't have to wait to go to LDC. You can go now, you see, and start understanding, why did counsel behave or argue in this way? Why did he present in this way? Or why did this counsel annoy the bench? Or, all of those things will be more than what you can get in a classroom. The other thing which I want to talk to, a lot has been said, is legal English. And I know we are also going through a generational change. But I think as you are going to the bar, I think it is good because, like the head panel said, and also Justice Kaswaga, we're dealing with a profession. A profession means that there is some uniformity in how things are what and how things are done. So, for example, you may end up going to Justice Kaswaga's court in Arusha, which is a regional what? Regional court. They will expect you to have that standard. I was also in a regional court, the East African Court of Justice. And it was very easy for us to see those who are ready to practice, not just domestically, but also regionally and internationally. So, for example, for the clerk, and I know this word has come from somewhere. I don't know where. I looked in the dictionary, I couldn't see it. Perhaps it is there in AI. Perhaps we shall check. It is X versus Y, not X versus versing. I know people like saying Arsenal is versing Man U. Yeah. I hear this a lot on the radios, and that is street what? That is street talk. In the court, you are verses. Yeah? Okay? You don't, if you go to the International Court of Justice, where Justice 17 is sitting, and say, this is versing the other one, everybody will remove their glasses to look at you better. You see? So I think that is one. Secondly, all of you are, when you appear before us, you're advocates. You're not counsel. Yeah? So you are Masolo Adrian, advocate. We want to know that you're what? Advocate. Yeah? Why? Because you have a practicing certificate every year that you get that indicates that you're an advocate of the courts of judicature. It does not indicate that you're counsel of the courts of what? Judicature. I know everybody wants to have a title. But if you want a title, you work for it, you know. You work for the what? For the title. If you think that Mr. or Miss or Mrs. is not heavy enough, and you go to your friends, who are not in the... My name is Counsel Adrian. So please, even I hear this in the accountants. They come to you and say, for me, I'm CPA. So and so. No. You're either a chartered what? Accountant. But you don't put what you are before. Perhaps one day you become a professor, God willing, a doctor. It is okay. But counsel does not add volume to you. The other thing which I also, in terms of language, and again, decorum has been mentioned over and over again. Even though we practice an adversarial system of litigation, the person you work with is your friend. That is not by accident. It keeps your decorum in check. So you say, my learned friend. All right? But people are saying co-counsel, the other counsel. Is your what? Learned friend. So, oh, my colleague, people come to court and they are on opposite sides. And they say, my lord, my colleague has argued like this. How can he be your colleague when he's on the other side? So you just keep it simple. That's why I say go to court and see how it is done. Those are your learned friends. It is very important for me to amplify what Justice Luswata has said. The oralist, the old oralist, is going out of the court system. Are we together? When I started practice, people would be allowed, they would ask, how much time do you need? And say, 1 hour. The courts no longer have time to give you 1 hour. You'll be lucky to get 20 minutes. So the lawyer of the future is the one who can summarize what the lawyer of the past said in 1 hour in 20 minutes. Yeah? Does that make sense? So your skills must be in the ability to convey a message that you would have said or delivered in 1.5 hours in 20 minutes. Sometimes they'll just give you 15. And therefore, organize your presentation. And this brings me to what we now call public speaking. You must be good at public speaking. That's not to speak nicely. Public speaking, not speaking what? Nicely. It is capturing your audience. When you go to court, people are tired, they have been doing other cases. You are going left, right, and center. They're trying to get, where are you going? Where are you coming from? For me, I would like to advise you that the best place to start is at the end. Because that's what you have gone to court for. But I noticed in this moot, you all started at the beginning. You want to be very clear that, like what my sister was talking about, for example, you must be very clear that even though you don't have a lot of time, what you want the court to do has come out clearly, the remedies. Because everything else will be lost in the verbiage. Know why you have gone to court and start there. Because then you immediately capture. And I think one of the teams I was very happy, I can actually say it, the Attorney General was able to say, I have 3 points. So you can be sure that the judge will wake up, say, thank God they are not 20. And give you what? Audience, yes. So you need to be able to deliver a lot in a very short time. Where you cannot go into detail, then you must learn to write very good briefs. That was not necessary for this, but there are some moots I have attended where actually we get briefs. Written what? Some of you may have attended those type of what? Moots where you're expected to give a what? A written brief. You can refer to, for greater detail, you look at page 6, paragraph 2. That's where I have discussed this point in what? Detail. You have highlighted it, and then you have delivered it. So the rest, I think, has been given, and I'd like to once again thank the organizers for putting this together. Oh, the last point, which I had not written here, but the very, very last point. Law is not something in the vacuum. Law does not operate in a vacuum. It's very important that the law is applied in a way that benefits not just your client, but also society. And I say this with great caution because right now there's a lot of copycatting. You copycat what other jurisdictions are doing. Because they are doing it, you can also what? Do it. So it becomes the what? It becomes the norm. You must always know what context you're arguing. If you're arguing in a Ugandan context, argue in a Ugandan context. If you're going to a regional court like Justice Gaswaga's, argue in a regional context. If you go to his and over-argue in a domestic context, you'll be lost. If you go to the ICC or the International Criminal Court, you see, also argue in that what? In that context. This is very important for you to know what court you are speaking to. Thank you very much. I wish you the best of luck in your studies and your careers to come. God bless.
Thank you, my lord, my lords. Most of it has been said. I will just emphasize, in your presentation, you need to work on the structure. And you know the structure, brief facts, you have the issues, you have the law applicable, apply the law to the facts, resolve the matter and conclude. If you have that structure, it will guide you and it will help you be very organized. I will just say something about brief facts. Brief facts determine the trend of your discussion. You could be witnessing the same thing and brief facts are separate. You must state the facts in such a way that they support your case. In other words, highlight the important aspects of the facts, because there are some facts you will want to mute, others to highlight without withholding information. Next, we go to projection. So as lawyers, if you are going to be an advocate, go to court and argue, or even a professor of law, talking is part of your tool of trade. So you must invest in it. There is nothing like he was born a good speaker, me, I was not born a good speaker. If you are a lawyer, you must work on your projection and diction, and so you must invest. These things don't come accidentally. The people who eventually excel invest some extra hours. There are some things called soft skills. You must invest in them and get trained and coached and all. It's like a musician. They have to keep working on their voices and so on. So there are courses where they will teach you how to project, how to communicate, and that kind. In addition to studying law, you should look at this. And then has been talked about demeanor and decorum. They go hand in hand. Why is decorum and demeanor important? One day, counsel came before us at the Supreme Court, and one of the female judges noticed that the gentleman was putting on a lady's blouse. Yeah, the lawyer. And so when he started submitting, she said, wait, let me see that shirt of yours clearly. Can you move the gown and I see? And then even the flaps. Basically, decorum, what it did to the young counsel completely disorganized him. He could not submit after that. So decorum is not just for you to look good. It helps you ensure that you are in control and you are not put off point. And it also means you get there on time. If you get to the court, you are sweating, you are late, it will, I can assure you, disorganize you, and you lose almost 50% of the marks. And you have points, but the just says, they talk about first impression is a lasting impression. I must first be confident in you before I internalize what you are saying. But if my impression of you is, this doesn't seem like a serious lawyer from his appearance, I'll begin saying, but does he even know what he's saying? Can I rely on him? Because what the justices are going, they want to be confident that I think I can rely on what this lawyer is saying. He seems confident, he seems to have researched, and he seems in charge. We don't want to be reliant on somebody who we are doubting where he's coming from. And then the issue of rebuttal responses, right of reply. When the other side raises issues, points, and all, you cannot afford to leave them unanswered. That is the use of rebuttal. And then you must prioritize which ones are important to your case and their case, and you respond. Likewise, if they have raised issues, you must, for lack of a better word, punch holes, so that the judges are saying, oh, he said this, but the other side raised this doubt, and he has not helped us resolve that doubt, and all. All said, I think you did very, very well, as has been exhibited by their lordships in talking to you, and we are happy with the standard of mooting and submission. We thank you very much. And we thank SEHAD, the organizers, for investing in you and taking all their time and resources to invest in the future generation of the legal profession. I will move straight ahead and tell you what the results are. We've just done a summary and aggregation of it. Will not tell you who scored what and all. We'll just give the aggregate scores. And I will begin by announcing the individual points that were given. And we'll start with Susan Kamukama, who got 71%. Let's give her a big hand clap. Next, Marvin Ainebiona, 77%. Next, Adrian Masolo, 79.6%. And last but not least, Linda Mirembe Namlema scored 80.6. As you can see, that was quite tight between the two of them. It was just a percentage point, 1.0. And therefore, your best oralist for today, Linda Mirembe Namlema. As far as respondents, appellants go, the final scores, the respondents team average was 74%. Let's give them a loud hand clap. And the appellants team average 80.2. Therefore, that means in this context, the appellants have taken the day with scoring 80.2%. The interesting thing is, just Kriawire was now asking me which universities were in the final. So we didn't know, and now I take this opportunity to hand over the mic back to the organizers, and they can take us through to the next level. Thank you very much. Please give their lordships another round of applause for their time.
We are more than honored, your lordships, for the support and guidance. And I also don't know which university won, so can I be guided on what the universities are? Please.
So, as the Moot coordinator, this is where I get to know information that they don't know. Anyway, CLMF, who are the appellants, were Cavendish University. And CLMG, who were the first runner-up, were Bishop Stewart University from Barara, by the way.
Congratulations to you people, and congratulations to the other 12 universities that we are part of this. We never get to know this information, by the way. So I am honored to know that, was Cavendish the winner last year as well?
No, last year it was IU.
Last year it was IU Mbale. So we congratulate the appellants, Cavendish University, and we congratulate you. Okay, so I am going to kindly request your lordships that you allow us just a few minutes to award the students, and that I will again request that you allow that at the end of this session, we take a photo with the students, all of them. So as the norm goes, I am going to request that you join us to award the students. We usually do the awarding from down here. And I'm going to request the students to kindly push back the chairs. And I'll request the executive director to join us as we do this celebration. Students, please be notified that the judges want to leave. And I know that we are holding on to their time. So if we read you for a certificate and you don't move faster, you'll miss a photo with them. The camera people, please just be attentive because you're going to just give each student 1 second. So if you may allow your lordships, please join me here, as well as the executive director and our colleague from CRR, to please award to take here. Thank you so much. Edie, please join them. Please join them. So, Esther, my phone. So our winners for the day are coming in from Cavendish University. And therefore, they took the trophy. Why aren't others clapping? Where is the morale for yesterday? We are all winners, right? Okay. As the first runner-up prepares, and please don't go because you are supposed to also get the gold medals for the two people that appeared before the judges. You will take the honor to have this dressed onto you by the judges. The two people that appeared, the motors, please. The judge. I think they still want. Thank you so much, Your Lordship. Can we have the first runner-up from Bishop Stewart? Bishop Stewart. Our first runner-up. Congratulations to you. Why aren't we clapping for Bishop Stewart? Again, as the first runner-up, they received the silver medal from the judges. So, as this happens, shall we please have the coordinators? I will read one by one to our dear judges. The students are coordinated by either lecturers or fellow students in the various universities. And therefore, we again going to request you to please take the honor to award their certificates. Norbert Kasigazi, please be first. So please receive your certificate from the judge that has it, and then you take your photo moment in a second, and then we'll read another. Anguzu Raymond, please prepare. This supported the students to prepare. Anguzu. Norbert is from Makerere University. Anguzu is from KIU. Joel Jerry is from the International University of East Africa. Joel. Joel, where are you? Are you Kampala? Please prepare. Biamukama Andrew from Bishop Stewart University. Baluku Joshua from Metropolitan International University. Ejiku Justin from Gulu University. Okay. Tamale Ahmed, Ayumbale. Muchibi Sharif, IU Female Campus. Please be fast. As Nambafu, you prepare. Muchibi Sharif. Nambafu, are you getting here? Andrew from Kumba University. Nimusima Brighton from Uganda Pentecostal University, Kampala. Mary Fravia Nakamate from King Caesar University. Eric Habu, UPU Fort Portal. Eric, where are you? Ayeranga Godfrey from Cavendish University. So, colleagues, I know that the students that appeared before the various judges yesterday and today also wish to have a photo with the justices today. So I'll read the name and you please be fast. I might not read the university, but you know the names. At least they know which universities participated by now. Ayebare Innocent. Koja Sarah. Ayebare, where are you? Koja Sarah. That's Ayebare. Please move. Koja Sarah, Abba Janet, Joanne. Abba, where are you? Serunjo Jisubi Audrey. Arinda, Lord. Arinda, where are you? Pinyoloya, Brenda. Brenda, where are you? Odemo Stephen, please be fast. Ojambo Stephen. Akate Kateka, Fiona. Kakembo Hassan Waswa. Fiona, where are you? Kakembo Hassan Waswa. Asio Elizabeth Mary. Asio, where are you? Yes, Asio is coming. Masoko Christine. Tembula Nusra. Nusra, where are you? Okay. Masoko Christine first. Then Tembula will receive after. Nansubuga, please come, Mercy. Nansubuga Mercy, as Ainebiona Marvin comes. Nansubuga Mercy, please be fast. Marvin. Kitimbo Alison Faith. Marvin is here. Marvin is this one. Yes. Kitimbo. I love the vibe here. It's a young people vibe. The other side, I just don't know. Asimwe Faith. Kusasira Favor. Bionanevie Kelly Martin. Martin. Ojuka Sadrak. Sorry. Okuja Sadrak. Apologies. Ruth Namirembe Hills. I love the name. Alari Constance Ogwando. Namirembe Hills, okay. Yes. Halari is this one. Okay. Musoke Samuel. Nansamba Jocelyn, Letitia. Nansamba, where are you? Bashir, Rumaisa. Nansamba, Bashir. Bashir is this one. Ayevale Johnson. Ayevale. Kamukama Susan. Kamukama. If you don't smile like we said yesterday, it's your photo. Mirembe Linda. Masolo Adrian Naliang. It's the vibe for me. Let's keep that for later. The journalists must be saying, can you give us that vibe? So, thank you so much. I'm going to request that their lordships don't sit, but that they accept to be awarded for the support provided, but also the guidance to the students. Please allow to accept the certificates from us. And this will be done by the ED. Honorable Justice Mike Chibita. Honorable Lady Justice, Honorable Lady Justice Eva Luswata. Honorable Justice Geoffrey Wilfred Shirabire. Honorable Justice Duncan Gaswaga. Honorable Lady Justice Ida Nachiganda. Thank you so much. Allow me, your lordships, to appreciate you so much for presiding over this moot, but as well as the justices that appeared yesterday, the magistrates from the various magisterial courts. We really appreciate you and honor that. I am going to also appreciate the team that supported and congratulate all the universities that have participated in this year's moot. Like indicated earlier, we got 15 universities apply. One pulled off because the moot was colliding with the exams, but I'm sure we missed the vibe in them. I also wish to appreciate the partners that supported this moot. We got support from Reproductive Health Uganda through the Right Here, Right Now program that we've been running, and Sonke Gender Justice through the Generation Gender program that we've been running, and Wellspring Advisors, we so appreciate. And the moot has been led by a team of staff who I am going to be calling upon one by one, and they have a photo. The moot coordinator from us has been Miss Dafa Esther. So we appreciate you, Esther. And Esther is supervised by Miss Ajalo Ruth, who is also our head of the Strategic Litigation Department at SEHAT. We appreciate, please don't go back because you're supposed to take a full staff photo after this. Ruth, please be fast. We thank you so much. Within the litigation department, we also have Nakalembe Judith as one of our advocates, and Miss Nansongo Faith, again as an advocate. Usually, your lordships, we award the best oralist for 3 months internship at SEHAT. One of those for last year is taking an internship with us, Shakira. She sits in the litigation department. I'm not sure she's here now. Shakira, please join us. And that automatically means that Miss Linda, what's the other name? Linda Mirembe is obviously given a space at SEHAD for the 3 months. She's free to tell us within what time period she wants to take us, so that the coordinator will get to her to let us know when she wants to take her internship, but it's automatic, it's given. We appreciate you so much. And that, with my supervision, is the litigation department. And we have our head, the executive director. So that team has been the core at the front of the Moot. But we believe in collaboration at SEHAD. So that team has been supported by various individuals who might not be here. The lead of protocol today was Mr. Seth Nimwesiga, who is also an advocate. Seth, where are you? Seth is the one that led the judges into the room. But we also had a team that came here to find out if the hotel was suitable for the Moot. And the procurement team is not here, but it was led by Miss Maureen Kwabacha, as well as Miss Bukira Immaculate. She's seated somewhere there behind. Buki, you need to come because we need the photo. And these have been supportive in terms of logistics. And Mr. Chibuka George William, I don't see them. They need to join us for the photo with the judges. And the person who has been leading the Tally Center is also our head, Human Resource and Administration, who is Miss Matovu Florence. Please join us for the photo. The team has been supported by a communications department. Everything has been live, and we have several photos we'll be happy to share with you. Our communications department is led by a coordinator, who is Ms. Twemanye Jacqueline. Jackie, people want to see you. Don't expect a very fat person, guys. Jackie, where are you? Out. Please come, people want to see you. As well as Miss Nabunya Faith. They're arranging the space for the photo. So those are our young people. They're already thinking about the group photo. But we appreciate them. I'm sure they've interacted with you. And this team has been supported by the photographers who have accepted to take a group photo for the staff as I join. I have been supporting all these as Deputy Executive Director. So I'll smile for the photo now. Staff to sit, but it will be very unfair of me if I really don't ask the lordships to take a photo with the clerks. We have had a team of clerks who have really supported us so much to clerk in the various courts. So I call your name, you kindly run and take the photo. Kasibante David, Chelangat Esther, Ochuku Patricia, Hira Annie Abigail, Mesigwa Lydia, Joseph Lagen, and Apollot Linda. Please come for a photo with the judges. And as they take the photo, I am going to request that the winners prepare to take a photo with the judges. Remember, we are working with 2 minutes of the judges, so you better prepare to come. The winners, thank you so much for that photo. So the winners, Cavendish University, kindly come and take your photo with the judges. As the first runners up, prepare. If you don't smile, it is your photo. Okay, so as the first runners-up prepare, please prepare to come or join us. Bishop Stewart Timbara University, please join us. And you realize that we have been trending on social media, and the trending has been supported by a team of the young lawyers, which I really want to call upon to have a photo. The more you delay, the more I'm going to release the judges. Shall we have the young lawyers who have been supporting with the trending? Please be fast. It is very bad to be an MC of a function. You miss out on all photos. Where are we, guys? Are we about to get here? Great. All right. Thank you so much. Please have the honor to take a photo with the judges. So it will just be fair that we have photos with all universities, right? So I'm going to request, I don't have the universities in order, but I'm going to request that, I know Cavendish is done, Bishop Stewart is done. Can we have a photo with Nkumba University? Please prepare and come. Let me get the list here. Nkumba University, are we there? If we are not, can we have Makere? Nkumba is here. Esther, I need your support. Nkumba University, your lordships, that's a team from Nkumba. Makere University, prepare. UPU, prepare. So that's Nkumba. Oh, was that Nkumba Makere? Makere. Makere is not here. Nkumba. Metropolitan. Metropolitan, please hurry. We are standing between the time of the judges and you need the photo. Pardon? Makere is here. They're here. Let the team from Makere first take the photo, please. No, Makere. After Makere, we'll have Metropolitan. When I call IU, please come together. Both campuses, right? 3 of them. Okay. Thank you, Metropolitan. Metropolitan. Thank you for participating. Please curve, just curve. I'm sure we can fit. IU, the 3 campuses should prepare. Ah, but where are the smiles? Ish. Are we ready? I have not seen anyone stand. So I'll get to another university. They're where? Please hurry. UPU, the 2 campuses. After IU. UPU, are you preparing? Where are the smiles, Vanange? Even Uganda got off Chan, but we are smiling. Ah. Hey. UPU, are you ready? Do you need support? I said I'm a multitasker. You need support? Yes. We apologize, but these are 3 campuses in one. Is that enough? We need 5 chairs. 5. Can I please borrow your chair? If I was a young person like you, I would have pulled it for the judge. Thank you. 1 more. Thank you. Thank you so much. But you students, we expect the smiles. Don't say the Seha team took a very bad photo of you and the judges. It is you to make it nice. UPU, are you ready? So when you come, please just stand behind the judges. We are not going to ask the judges to stand again. KIU, are we preparing? UPU, hurry. Fix yourself behind the judges and we move. KIU? KIU, prepare. As the IUEA prepares, please smile for the photographer. He's not saying, but I know he wants you to see you smile. Your photo is not balanced. Maybe you extend this side. Yes. KIU, we should be moving. Faster, faster. IUEA, please prepare. And I swear when I say Guru, that will be the last photo. KIU, KIU is here. So IUEA is preparing. Remember, it's your photo. IUEA prepared? Perfect. King Caesar, can you prepare? You see what they did? That is awesome. King Caesar, where are we? As School University prepares. King Caesar, as School University prepares. So as King Caesar prepares, I am going to take the opportunity to just raise awareness of some of the developments in the country. I wish to update you on students who are presenting on the King Caesar's number. We noticed that you actually are not aware that Uganda has what we call the national establishment guidelines in place, and these will not individualize student abortion. Also noticed that the country, Gulu University is coming. We noticed that you are not aware that Uganda picked so many resources from COVID-19 and developed the 2021 revised national guidelines for the prevention and management of teenage pregnancy in schools. And these guidelines give guidance on school re-entry after 1 year of treatment. So I hope that you have taken note of that. Have we had Gulu University here? So I can't say that the photographers will come for the photo, but I'm going to make a kind request that the judges I know that people want to come here to get the benefit of it. We're extremely interested in trying. These are the outcomes that the photographers that we take. And having done that, once we finish, we have our judges have lunch. And the students will come back to the guide that have lunch. I really want to thank you so much for everything that has gone on. Don't look at any team member, just look at me. And I swear, I'm sorry. As an institution, thank you so much. Say, please lead the judges. Please allow the judges to move, then you can follow them. Say, humanity, please come. Thank you, and we wish you a happy weekend. As I said yesterday, we'll be celebrating Sehan at 15 next week on Thursday, and please register to attend the conference.
Students, after the photo, please come back for your lunch coupons to me. After the photo. Lunch first, then.
The bag, yes, yes. But